The House Committee on Elections will come to order. The clerk will call the roll.
Chairman Smith,
Here?
Vice Chair Busey,
Here.
Rep. Burrows, Rep. Capriglione, Rep. Deala,
Here.
Rep. Manuel,
Here.
Rep. Morales, Rep. Swanson,
Here.
Rep. Vo.
Here. The quorum is present. Folks, as a reminder, anyone wishing to present testimony before the committee, please register at the kiosk located in the hallway behind the hearing rooms. If you require assistance in registering or testifying, please contact the committee staff. Due to the number of witnesses who have registered and to accommodate all who wish to testify, there will be a time limit of 3 minutes per witness during the public testimony period. Continued reminders, committee members, as a reminder, please remember to check out the publicly available comments. These comments are left by the public on each agenda item in our hearings. Comments are open until the end of the hearing and are posted upon adjournment from our hearing. If there's nothing else that we need to discuss, the chair lays out House Bill 87 and recognizes Representative Murr to explain the bill.
Good afternoon, Mr. Chairman, committee members. Currently, the state of Texas does not have any laws relating to faithless electors when casting a presidential or vice presidential vote. A faithless elector is an elector who votes in the Electoral College for a candidate other than the one who won the popular vote in that elector's state. House Bill 87 establishes an oath for presidential electors so that they must swear to, before casting ballots, for the candidate who receives the highest number of popular votes, as well as positions for the replacement of electors who do not faithfully abide by this oath. This will ensure faithless electors' votes are nullified and will replace the current elector with someone better suited to fulfill the responsibilities and uphold the oath of elector. And let's be honest, a lot of our constituents don't fully understand the Electoral College. And so when we do have a presidential election, the presumption is that the majority votes of the state, they matter and they count. And that's why it's so important to put some guardrails on the electors that are sent from the state of Texas to participate in that process. Just a couple of historical notes that I'll throw out for you. Over 58 different elections, 165 electors have not cast their votes for president or vice president as prescribed by the legislature of the state they represented. In 2000, one elector chose to abstain from voting for any candidate. 93 were changed, typically to the elector's personal preference, and although there may have been mistakes, they don't get counted. Finally, 71 electors changed their votes because the candidate to whom they were pledged died before the electoral ballot was cast. That's in 1872 and in 1912. And I'll give you another reason why this is important to us. It's based on precedent in 1872 when Democratic nominee for president Horace Greeley died just after Election Day. Some electors still cast their ballots for him anyway. Those votes would not count in the final Electoral College tally because dead people are not eligible to become president. And so in that scenario, if it's not done properly, that could leave an election with no clear winner in the Electoral College and forcing a decision to not to the Texas House of Representatives, but the United States House of Representatives. So that is the goal that we have with this bill. We're trying to make sure that both there's not ambiguity in the process and there are guardrails to ensure that it's done properly. So the final thing, the version that you have in front of you was voted out of this committee 8-0 last session. This bill passed off the House floor 142-1, Mr. Slayton, and it passed out of Senate committee 9-0 over in the Senate. It just ran out of time to finish the process. This bill in front of you, after hearing testimony last session, it was acknowledged that it was acceptable to the Democrat Party of Texas, the Republican Party of Texas, and the Libertarian Party of Texas. So I worked diligently to make sure that this was fair policy for all across the board. And I'll leave you with that final note that we owe it to our constituents to plan, just as though I represent a lot of rural ranchers. You always plan for the worst and you hope for the best. So you make plans according to days that you may never have to execute those, and I think that's what this does. So I'm happy to answer any questions and respectfully request the right to close.
Thank you, Chairman. The chair would note that Chairman Burrows is with us. Members have any questions? Okay. Well,
Thank you.
no testimony. Thank you. The chair would call Dr. Susana Carranza.
Hi,
Are you Susana Carranza?
yes, I'm Dr. Susanna Carranza.
Are you here testifying on behalf of yourself?
I'm here to testify on my own behalf.
Are you against the bill?
I am against the bill, and I'll explain why. I agree with the principle that was explained by the author, but just the portion of the bill, how it addresses like that the electors have to, I forgot the exact language, but to certify or deny certification for the candidate before they vote. That part makes me nervous because it seems to open the door for somebody to decide that, there's some sort of a coordination to decide that that's a way around the faithful electors. So I agree with the intent of having faithful electors, but in my view, I think that provision to allow for alternate candidates if the members decide that the current nominee is not fit or whatever, opens the door for somebody to use that as a way to not obey the will of the people. So that's my grounds for opposition. And maybe I misunderstood the bill, but the way I read, and I read many times, every time I see that as opening the door. Thank you.
Thank you, ma'am. Thank you for taking the time to come testify. Members, any questions? Okay, thank you so much. The chair calls Christina Adkins. All right, Ms. Adkins, now, I'm just going to call you up every time. I don't want people to think I'm picking on you or rude, but are you here as a resource witness?
Yes, sir.
Okay, so you're Christina Atkins, and you're testifying on behalf of the Texas Secretary of State's office, is that correct?
Yes, sir.
And are you neutral on the bill?
Yes.
Okay, thank you. Members, do y'all have any questions of Ms. Atkins? Okay, thank you so much.
Thank you.
Is that it? Is there anyone else who wishes to testify on, for, or against House Bill 87?
I registered.
Ah, you did.
I did. Cindy Castilla.
Okay, Ms. Christina, hold on just one
Do we have
second.
to clean it up?
Registered on House Bill 87.
We're not showing you registered on House Bill 87.
Okay, I went to the kiosk and I registered and I finished. I'm speaking for Texas Eagle Forum. I'd like to speak on the bill.
I'll tell you what, why don't we do this? If you want to do that, why don't you go ahead and go, can we register her here? Right over here?
Yes, we can register you right down here.
Thank you.
Okay, now let's get, hold up.
Okay, thank you.
May I go ahead and take a seat?
You go ahead and have a seat and let me
Thank you.
take a look at the record here real quick, okay? We want to make sure we got you in there correctly.
Got her in there now. Here we go.
The chair calls Cindy Castillo. You're Cindy Castillo?
Yes, sir.
You're testifying on behalf of the Texas Eagle Forum and yourself, is that correct?
Yes, sir.
And you're on the bill, is that
Yes,
correct?
sir.
Okay, go ahead.
Okay, understand the intent of the bill and really like the faithful delegate language. I think no matter what party wins the presidential and vice presidential nominations, the electors should be faithful. They were elected by the people of the party to represent the state's votes. So that's important to us. But the new language added, if you're looking at yours, it's on page 4, and it starts in 192.065. This does not clarify that there's a problem or a candidate who's been very disabled or something's happened between the 74th day prior to the election and the date that the electors are sitting down to cast their votes. It just allows the electors to, by majority vote, deny the certification that the candidate is willing and able to serve. So I would propose that in this coming up election, we could easily have electors who don't like their own party's candidate and would like to throw things into disarray. I think there's also people who would like to throw the Electoral College into disarray. And I just don't think this language is tight enough to explain that this is only in an extraordinary circumstance when the president isn't able, because it does give it does give the candidate an opportunity to certify. I think it should say if they, the next section says if they haven't
Where are you?
Okay.
Go.
I'm on this section 192.65, but on section B, that's where it says they can vote to affirm or deny the certification made under subsection A. Well, subsection A has allowed and asked the candidate or their legal representative to certify that they are willing and able. I feel like it should say purposely. On the next page, under C, if before the meeting of electors, a candidate, I would say purposely fails to certify that the candidate is willing and able. I would put purposefully, because I get what you're doing there, and a candidate who, the party's not having to try to replace them because they're brain dead, or something, then they would maybe purposefully fail to do that so that they can execute a backup plan. But that's going to be very, very rare. It's not happened often. If the majority of electors vote in that same section that the candidate is not willing or able to serve in the position, they're now released from D. And I think they would need further instructions there as well. What do they do if they're released? Because the party that's won nationwide probably doesn't want this to go to the House either. They want the will of the people heard.
All right. Have you had a chance to talk to the author yet about any?
Well, it's been crazy. We saw this late last week, and so I did talk to him this morning, and that's why I'm testifying on, because we've had a discussion about possibly working on that language to tighten it up and make it a really specific circumstance that our electors could free themselves from Section D and from being, you could conceivably have a whole bunch of bad people in any party run to be electors and then just throw out what we, the people, did at the election.
Thank you, ma'am. Thank you for your testimony.
Okay.
Members, any questions?
Okay, thank you.
Thank you so much for taking the time. Is there anyone else who wishes to testify on, for, or against House Bill 87? If no one else, then the chair recognizes Representative Murr to close on House Bill 87 and recognizes that Representative Morales is with us.
Thank you, Mr. Chairman. I appreciate the witness testimony. If I heard correctly from witness testimony today, is they're supportive of the language in the bill. There are 2 sections, the bottom of page 4 and the top of page 5, that give them pause. But beyond that, the overall intent of the bill and the goals on other pages are acceptable. And so what I pledged to the committee is, again, I'm worked very diligently to make sure that everybody's on the same page with this, and it's good policy for the state. So I'm gonna try to connect with both witnesses and get input so that I can bring you back a committee substitute that accomplishes what we want it done as far as policy. So thank you for your time.
Yes, sir. Any questions of the chairman? Okay, thank you very much. If there's no objection, House Bill 87 will be left pending. I hear no objection, the chair hears none, and House Bill 87 is left pending. The chair lays out House Bill 1003 and recognizes Representative Shaheen to explain the bill. Good afternoon. The chair, I think you have a committee substitute, do you?
Yes, sir.
Okay, hold on. Representative Busey offers a committee substitute. And I'm now recognize Representative Shaheen to explain the bill.
Thank you, Chair Smith, Vice Chair Busey, members of the committee. House Bill 1003 seeks to make an individual ineligible to serve as an election poll watcher if the individual has been convicted of a felony. So we're talking about murder, rape, arson, child pornography, drugs, those types of crimes. Our elections are sacred, and integrity in our election process is, of course, vital. However, despite the fact that there are a large number of jobs that are not available to those convicted of a felony, currently a person could be a poll watcher in Texas with a felony conviction. Jobs not available to those convicted of a felony include, of course, law enforcement, emergency medical personnel, people in the financial services industry, jobs in our schools, of course, serve on a jury, some state agencies, etc. I certainly believe in redemption. However, it is reasonable to withhold certain responsibilities from individuals who have been shown to make poor decisions. So House Bill 1003 makes a person ineligible to serve as a poll watcher in an election if the person has been finally convicted of a felony or an offense in connection with an election. With that, Mr. Chairman, I'm happy to take any questions and reserve the right to close.
Thank you, sir. Members, any questions? Representative Busey, Vice Chair Busey.
Thank you, Mr. Chairman. Thank you, Representative. I know we've worked on this bill in the past. I just have a clarifying question to start. Would this, if this bill was to become law, felons who have served all their time and are off paper, as we refer to it, would they still be banned under your bill?
Yes, sir. So they can, once they've served their time, they're eligible to vote. But like these other jobs that I've given examples of, they would not be able to serve as a poll watcher.
And your committee sub deals with misdemeanors around election.
The committee sub actually does two, it covers all felonies.
Okay.
And then I think
I'm wondering.
the misdemeanor might have been
A misdemeanor offense in connection with the conduct directly attributable to an election.
Yeah, that's right. That's in there because when you make it all of the felonies, that covers those election violations that are felony related. So that's adding the misdemeanor.
Sure. Well, respectfully, I know we've clashed on this in the past. I would love to find a compromise if you want to talk about it offline some more.
Sure.
One thought I have, and just to put it out there now, then we can talk about it more, is I think my big hesitance has always been once they've regained their right to vote, I would like to see them have full rights back in society. And that's why I've opposed this bill. Maybe some compromise language that if they regain their right to vote, they would have this right back as well, except for people that have crimes tied to elections or, skirting democracy, January 6th type stuff, or election violations. If there's some compromise there, I'd love to work with you on it, but we can talk offline.
Yeah,
that's my thought.
Sure, I'm always available.
I appreciate it, Representative.
Yeah.
Thank you. Thank you, Mr. Chairman.
Any other questions, member? All right, thank you.
Thank you, sir.
The chair calls Alan Vera. Good afternoon, Mr. Vera.
Good afternoon.
I understand your name is Alan Vera,
It is.
that you're testifying on behalf of the Harris County Republican Party Ballot Security Committee, is that correct?
That's correct.
And that you're for the bill, is that correct?
Correct.
Go ahead.
Thank you. Poll watchers play a critical role in observing, recording, and correcting errors or omissions in compliance with the Texas Election Code. And they must carry out their important duty without interfering with the smooth conduct of the election process they're assigned to observe. They have to be people of impeccable character and conduct. The Election Code already has restrictions on election participation by convicted felons and individuals convicted of election offenses. This bill simply extends those same provisions to the important role of poll watchers. It is clear and simple adjustment for greater consistency throughout the Election Code. Brace yourselves for meteors to fall. I'm going to agree with Mr. Busey. However, on a side note, when convicted felons who have lost their right to vote have completely satisfied all the terms of their penalties when they're off paper, TEC allows restoration of their right to vote. This bill is unclear as to whether convicted felons can ever regain their eligibility to serve as poll watchers. We suggest that issue be addressed clearly so there's no debate or misunderstanding later on. Overall, it's a great bill. We urge the committee to give favorable consideration to HB 1003.
Thank you, Mr. Vera. Members, any questions? Thank you so much. The chair calls Kevin Hale. Okay. All right, so apparently Mr. Hale had to step out. Is that right? Okay. Yes, sir. The chair calls for a cameo appearance Christina Adkins. Okay, so you are Christina Atkins,
Yes, sir.
and you're testifying on behalf of the Texas Secretary of State's office?
Yes, sir.
And you're here as a resource witness, and they're on the bill.
Yes, sir.
Members, do we have any questions of Ms. Atkins? Thank you so much.
Thank you.
The chair calls Ed Johnson. Good to see you again, Mr. Johnson. You are Ed Johnson, is that correct?
That is correct.
You're testifying on behalf of yourself, correct?
That is correct.
And are you for the bill?
I am for the bill.
Go ahead.
Okay, thank you for letting me talk about this. In my past jobs and duties working in elections in Harris County, we had problems with this quite often in polling locations where the election judge or the election workers would not feel comfortable with a poll watcher that was known of committing felony crimes, murder, things like that, rape. And several of the ladies, or even sometimes gentlemen, would not want to be in a closed situation in a room all day with this kind of bad actor. They did not feel comfortable. And we actually had election workers that refused to show up because of the poll watcher, and they knew this person from the neighborhood that they, didn't want to be associated with them or be in that close proximity. All the things listed before, we don't hire for. Employers a lot of times look at these felony records and won't hire people because of crimes that they've committed in the past because of the safety of their other employees. So I think we should consider that for election workers too.
Okay. Thank you so much. Members, any questions? Appreciate your testimony, Mr. Johnson. Thank you. Chair calls Dr. Susana Carranza. And am I pronouncing that correctly, Carranza?
Yeah, it's close enough.
Okay.
It depends on where I am in the world. I kind of use it differently.
I got you. All right. Well, state your name for me.
I'm flexible.
Could you state your name for me, please?
My name is Dr. Susana Carranza.
And you testify on behalf of yourself?
I'm testifying on my own behalf, and I oppose this bill.
Okay, thank you.
And I'm a VDR, which is a volunteer deputy registrar, register voters quite often. Whenever we encounter a person that is an ex-felon that regained their rights to vote, many times they don't know, but they're so rejoiced to know and learn what they can do. One of the reasons is that when you're a felon, you feel like dehumanized, that you're less than, you are not a person, your rights are revoked. So you pay your dues to society. You should be able to re-enter society. And being a poll watcher is like voting. It's part of society. You pay your dues. Why are you making people pay twice for it? So that's pretty much why I oppose. They already paid for it.
Okay, thank you. Members,
Thank you.
any questions?
And I'm also, I'm also a judge and election judge, and I would have no problem having them in my corner.
Well, thank you for sharing your perspective, Doctor. Appreciate it very much. Members, any questions? Okay, thank you so much. Is there anyone else who wishes to take, let's see now. Do we have?
No.
He didn't make it back. Who was that? Was that Kevin Hale?
She's saying no.
Kevin Hale's not back. Okay, thank you, ma'am. Appreciate that. All right. Is there anyone else who wishes to testify on, for, or against House Bill 1003? If not, the chair recognizes Representative Shaheen to close on the bill.
Thank you, Mr. Chairman. So I just want to make sure I'm clear on the committee sub. So it expands the prohibition to anybody finally convicted of a felony or misdemeanor offense in connection with the conduct of an election. So just want to provide that clarification. With that, Mr. Chairman, I close.
Members, any questions of Representative? Okay. Thank you, Representative. The committee substitute is withdrawn. If there is no objection, House Bill 1003 will be left pending.
Thank you, members.
Objection. House Bill 1003 is left pending. Thank you, Representative. The chair lays out House Bill 2800 and recognizes Representative Paul to explain the bill.
Thank you, Chairman and members. It's good to see you today, and thanks for the opportunity to lay out this important bill. I think this will be some good election law here that hopefully we can all get behind. Currently, the Secretary of State recommends that the County Election Board should meet no later than the 36th day before a general election due to posting requirements, but they can meet as soon as early as July. There are some counties currently not having county election board meetings at all. So they're not doing what's required by the law. There's not even meeting at all. In some counties that conduct their meetings just by phone or by email. HB 2800 states that county election board meetings shall be held in person and must be open to the public. It also states that if a county has a website, they shall post a notice of the meeting 48 hours before each meeting. This is a simple transparency bill designed to inform the public more about our elections and how they're operated. So it's a chance for the people to interact with their leaders as they're performing this valuable function towards a committee. And the county election board sets where we're having the elections, what times are going to be there, and what locations are going to be there. So it's critical that people know about it. And with that, I'd be glad to answer any questions.
Okay, thank you, Representative. Members, any questions? All right, thank you.
Not hearing that, reserve the right to close. Thank you, Chairman.
Yes, sir. Yes, sir. The chair calls Alan Vera. Mr. Vera, state your name, please.
Alan Vera.
Are you here on behalf of the Harris County Republican Party?
I am.
What security committee?
I am.
Okay, and are you for the bill?
I am.
Thank you. Go ahead.
The reason so many counties pay so little regard to the election board meetings is because they think they're just rubber stamps. They simply look at papers and approve them. I have personally witnessed, of course, in Harris County, heated disagreements and intense debates among the members of the election board over some of the appointments submitted by one or both of the political parties for election service. That's one of the key things the board does. It approves the early voting ballot board, signature verification committee, and central count from both parties. Since resolutions of these agreements have an impact on the conduct of each election, voters have the right to be aware of and to attend and observe the meetings. It's a good bill. We urge the committee to give favorable consideration to HB 2800.
Thank you, sir. Members, any questions? Thank you. The chair calls Kathy Hagler. You are Kathy Hagler.
I am.
You're here on behalf of yourself, is that correct?
Yes, sir.
And are you for the bill?
I am for the bill.
All right, thank you. Go ahead.
Thank you, Chairman. I have heard of counties where a sheriff who has been in office for several terms has never heard of this meeting, has never been invited to it, and was not aware he was on something called the County Election Board, and I won't name that county. I'm also aware of another county where an EA makes all the decisions that the board should be making, sends out the plan, sends it to everybody by email and says, this is what we're going to do. And these people never have a chance to have input. The sheriff and the county chairs for both of the major parties and the EA and the county clerk, I think, I may forget who all's on this committee, but there's just a few people on the committee, and as mentioned before, there's a lot of important things they're deciding. They also decide on what the early voting hours are going to be, at least in my county they do, and there's usually some debate about what they're going to do with weekends and all that. So there's a lot of important information here, and it's important to know who is doing what, because when they come up for election again, this is going to be something we want to remember, is how they're voting on the county election board. That's why the public needs to know about it. So just because some of the decisions they make are so important to the election, we just believe that this transparency is something that should be available to the public.
Okay, thank you so much for your testimony. Members, any questions? Ms. Hagler. All right, thank you so much. The chair calls Elizabeth Miller. You're Elizabeth Miller?
I am.
You're here on behalf of yourself, is that correct?
I am.
And are you on the bill?
Yes.
Thank you. Go ahead.
I apologize to the author for not having time to get in touch with you guys on this. I've participated in ballot board and early signature verification in Tarrant County. And so I just had a suggestion on this that might help. Sorry, I'm getting child alerts going off. One thing we could do with the notice is perhaps notify the county chairs rather than just posting it on the website. What happens at this meeting is they get the names on a list. The county chairs will give names on a list of who can serve. And so that's when they get a sense of, in Tarrant County, I get the sense we're not arguing. I don't always go to that meeting, so I can't tell you exactly how it occurs. But my sense isn't that the parties are arguing over names, but making sure we have enough bodies, right, to do all this. And that's a time when you can get a sense, do we have enough people on these lists to get the job done? And libertarians, we can be really helpful. We've been helpful. I hope your party counterparts will confirm that we've been helpful, because we're like utility outfielders, right? So when you need two people from every party to look over everything, we become useful. So keep us in mind, not just to be a pain, but to actually be helpful in this process. And so if you notified county parties, that would be one way. Another way to do that would be maybe just have people sign up to be notified of this meeting. I have at least one friend in Tarrant County who likes to participate in this process. She's a poll watcher, and she's very politically active, but she does not enjoy being associated to any of our parties. No offense to any of us. I can kind of relate to that some days. And she would prefer to be able to participate as an independent. And so if you guys in the future could just think about that, there are people out there, because this is all by the county chair does this and that and gets the names. Now, we can get her on, we know of her, so we can do that and give her the heads up. But if a way for people could just sign up to be notified, I think that would be great. So,
thank you so much, ma'am. Any questions from the members? Okay, thank you so much.
you bet. Thank you.
Chair calls Susana Carranza.
I
guess I feel talkative today.
Good to see you. Yes, ma'am.
Long time no talk.
Right, so Ms. Carranza, you are here on behalf of yourself, is that correct?
Yes.
And you're against the bills?
Yes. And here's the thing. I'm all for transparency. I think transparency is important. But the concerns I have with this bill is like with many board meetings, organizations and stuff, you usually have a public-facing meeting and the private meetings because there are some matters, especially related to elections, that might not be good to be open to the public, that might be sensitive information. So this bill doesn't allow for any discretion of having private meetings because like even my HOA, we have the monthly meetings that are open to the public, but after that part of the meeting closes, there is the part that is dealing with the business of the board that the public shouldn't be there because you're discussing things that might, disclose personal information from people. That there's a lot of things that there's no allowing for discretion of the board or even guidelines for this type of decisions might be public meetings, but the board can have some private. And I see this as actually a security problem. So people talk about breach of security, election integrity, opening every single board meeting, forcing them to be in person, not allowing for virtual, it's actually not helping. If the intention is transparency, maybe make allowances for public-facing versus not, virtual meetings so people can attend remotely and in many other ways. So anyway, if you have any questions.
Thank you, ma'am. Members, any questions? Yes. Representative Morales, excuse me.
Thank you. Mrs. Carranza, Doctor?
Doctor, yes.
Can you give us specific examples as to some of the material that you may be covering that you would claim should be more confidential or not subject?
So I'm not part of the elections board, but I know of a large number of different public organizations that there's part of the proceedings that makes sense to be public for transparency, but even like the city council, there are parts that you have to discuss. You have to have some level of privacy. For instance, if you're discussing some details of the equipment, it might not be a good idea for that to be public before some decisions are made, right? So there are parts of it that might breach security because you might be discussing too much information about where the polling places are going to be and decisions that are made that are things that might give enough information if somebody's actually trying to do like some sort of a security breach or go dox a person or anything like that. It would open the door for that. And again, I have never been specifically on that kind of board, but just any administrative body, any government body, there are parts that you can be public facing and it helps with transparency, but there are discussions that need to be held only with people that have authorized, the need to know for that kind of information.
I hear you. As city attorney for a number of municipalities, I understand, under the government code, chapter 551, you have the Open Meetings Act, and you take the position that everything should be open with a few exceptions under if you can qualify for them as a governmental body. But I've yet to hear substantive information. I would really hope if you can provide us some that would rise to that level. If there's machines and there's problems with the voting machines, I think that is a public issue that should be subject to public disclosure and should not be maintained in a confidential setting, for example. If you're talking about voting locations, I also don't see anything wrong with it, and we should be discussing openly where these voting locations take place.
And that's a fair point, and it is possible that there are very few things that the elections board have to discuss that would be privy from the public. But my concern is that this bill allows zero discretion. There is, and when there is zero discretion for that, I see that as a problem because then you might, we might get into, it's the whole thing of unintended consequences, right? We are adding a provision that didn't exist in the code before, and we're kind of going in uncharted territories, and we're not allowing for any possible scenarios where it's not a good idea to be public. So I'm not saying that we don't want to have any public meetings. I'm just saying that the bill as written doesn't allow any discretion whatsoever if there is any instances that would be problematic to have a public hearing.
So your position would be make it more subject to like any other governmental entity in the state of Texas where they would be subject to the Open Meetings Act and have to comply with the Open Meetings Act.
And they could have exceptions, exactly. This bill doesn't allow for that.
Right. And in that token also, are you also raising concerns over the issue of the 48-hour notice? Because if you subject a local governmental entity that is subject to the government code under 551, then they also have to comply with a 72-hour notice requirement. And I noticed that this bill provides for 48 hours.
I have no opinion on that.
Thank you. I'll ask the author.
Thank you.
Thank you, Mr. Chairman.
Thank you, Representative. Members, any other questions? Thank you, Doctor. The chair calls Christina Atkins. And I don't think you're coming up here for nothing this time, so that's good. You are Christina Atkins.
Yes, sir.
You're here on behalf of the Texas Secretary of State's office and on the bill.
Yes, sir.
Go ahead. Do you have any comments? I'll call Vice Chair Busey to question you.
Thank you, Mr. Chairman. I just want to understand the bill based on the last testimony. So as you read the bill, would this allow for this to be virtual or it has to be in person?
That's a great question. The way it's written now, I don't believe that it opts in all of the requirements of the government code related to Open Meetings Act. So I think that they could, as long as they have an in-person component to it, could allow people to participate virtually.
What happens if people get unruly at a meeting like this? What authority do people have to deal with whatever based on, we heard testimony about concerns about security. How is that maintained? Does this bill impact that?
I mean, I don't think the bill speaks to those details. I would want to point out that the county election board, like much of what they're doing is just serving an administrative function. There's two primary things that they do. The first is they look at the plan by the county election officer for the allocation and procurement of supplies. So what resources do you need for the election, ordering them and making sure you're getting them allocated properly. They approve that. So there's not a whole lot of discussion that goes into that typically. It's like I said, more an administrative function. And then beyond that, there are some appointment actions where they are appointing members of the ballot board and the signature verification committee. My understanding that in practice is that more often than not, before they get to this point, most of that's already agreed upon. And so there aren't a lot of big decisions that are made in this process because they're working that out prior to the meeting itself.
But your interpretation, this could be virtual.
Yes, because it doesn't speak to any of the provisions in the government code that may have those restrictions. There's a little bit more flexibility. I will, if I may, I will say, I did hear some feedback that, sometimes when you have law enforcement, like the sheriff that needs to participate in these meetings, sometimes it can be hard to get them to pin them down just because of other obligations they have within the county. And so sometimes giving them a little bit more flexibility, like virtual participation, would be helpful to them.
Thank you. Thank you, Mr. Chairman.
Representative Morales.
Yes, thank you, Mr. Chairman. Ms. Atkins, so can you tell us, maybe you answered it already, but I didn't hear you correctly. Are these type of boards subject to the Open Meetings Act?
I don't believe so. The way this is written, it's not opting them into any of the provisions in the government code that relate to open meetings.
I'm not talking about the bill itself, but just generally.
In general?
The election code, these.
County Election Board, I would say, is not subject to open meetings requirements.
Okay. And do you have an opinion for or against as to whether you think that these type of boards should be, or can you give such an opinion?
Well, sir, that's a policy decision for you all.
You're the expert on.
My secretary has made it very clear. I think her word in her confirmation hearing was she would have my head if I took a position on a.
Got it.
So,
I don't want to get you in trouble.
Resource only.
Got it. Do you foresee where the 48 hours, does that present a challenge also, or is that normal in this type of advisory board?
Well, as I was indicating, from what I've heard in practice from our counties, this is kind of an administrative function. They're signing off on plans that were typically already discussed and agreed upon. I haven't heard anecdotally about a lot of conflict in this particular area. There is an argument, I think, for having maybe a shorter notice requirement than the 72 hours you would see in traditional open meetings requirements, because they might need to meet a little bit more quickly or a little bit more regularly to adapt to situations that arise. So, I mean, it is providing notice to the public. You know, it's not immediate notice, so people can participate. I have not heard of anything that would make me think that there's objections or problems with that 48-hour time frame.
And last question, do you have any experience with respect to the previous person that came up here testified, to see if there's any examples of certain instances where some of the material may be so confidential in nature and possible result in a breach that we should open it up to sometimes having that exemption from the open meeting?
That was a great question, and that was a great point. I did think about that when that individual testified on that notion. I think I would say to that is that all election records are generally public. I mean, that's the default in the election process, is to provide transparency. You know, there's not a lot of things that would occur in the election process that would need to be confidential for security reasons, because we kind of have the opposite view on that from the election side, that we want people to have as much information as possible.
Thank you.
Mm-hmm. Sure.
Members, any other questions? Ms. Atkins, so kind of along the same vein as Representative Manuel, do you see any... Good Lord. Sorry about that, Morales. Yeah, thank you.
I mean, better looking.
Yes, absolutely. Do you see any legal hurdles in connection with this bill as it's laid out?
Nothing that comes to mind on this. You know, I think it's creating an additional type of open meeting requirement, kind of not with a capital O. No, so not government code related, but it is providing an open process. It's doing it through the election code, which I think gives them a little bit more flexibility with respect to the virtual notion, and you know, making sure that they're addressing the right issues in that meeting.
Okay, thank you so much.
Sure.
Members, any other questions? Thank you so much.
Of course.
You actually got to do something here today. Yeah, thank you. Appreciate that. Chair calls Ed Johnson. You are Ed Johnson, correct?
That is correct.
You're here on behalf of yourself,
That is correct.
and you're for the bill.
I am for the bill.
All right,
It's a
thank you.
great bill. I have been through this process, working in elections for 20 years, and all the stuff that was mentioned before about secrecy and privacy, there's nothing that happens here. This committee basically is supposed to be just a rubber stamp. What happens is every once in a while, they get a little wild hair and they go out and switch the people that are on the ballot board and put their own, change the names to people that they want instead of what the party wants. That's what you got to govern for, and you want eyes on this where they can't do it, in behind closed doors. So this gives it open to where the public can see that they don't switch the names. All the stuff that they're voting on goes in front of Commissioner's Court before it gets to them. The election plan, the purchase equipment, all that has to go through Commissioner's Court and get approved by Commissioner's Court. The ballot board submissions go through the court. The times and places of the polling locations go through court. So Commissioner's Court's reviewed all this. They're just the rubber stamp on it. But they do have the authority that they could monkey with the names on the list. And this would give it to where the public can go in to make sure that they don't do that.
Members, any questions? Okay. I was about to get it right, too. I was going to say Representative Morales.
I saw it still on.
Okay. Okay. Thank you so much, Mr. Johnson.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 2800? If not, the chair recognizes Representative Paul to close on House Bill 2800.
Thank you, Mr. Chairman, members. I want to go through a couple extra points as Vice Chair Busey was mentioning. He wanted to make sure that security was there because this is something that people want to see. And as far as opening meetings and open, it's illegal for the state of Texas to have any meeting that's not publicly open. I mean, we can't meet at all for no matter what reasons without doing it. the counties already have purposes of meeting, everything is shown. So I don't think there's any chance that we need to have a closed meeting with this. In fact, the intent is to make sure that it is open so everybody knows that they're not doing something in secret and then cause people to be suspect. They never deal with personal information, so there was no chance that somebody would have personal information done. So I don't see a reason to have some kind of closed meeting with this group. It's actually what we don't want to have. Again, the goal of what we're trying to get at is sometimes he's not even meeting at all, and people that are part of the committee are not even notified to even okay it by email. So again, we want to make sure that everybody that the state of Texas has said is part of that meeting if they so wish or not. We also felt that everything was open to public testimony, because all county meetings, most of them are already open to public testimony. So this is a function of the county. It is a function of the state. And those are open to all sorts of meetings. People also having a chance to access that through Zoom. If it needs to be clarified, we're glad to do that, because obviously that's the whole idea. We want people to be a part of it. The major parties are part of this committee, so they're obviously notified that they're going to be at this meeting because they sit on the board. Anybody else in the county will be notified immediately by the fact that it's sent out. I mean, it could be tons of people that need to know about it or want to know about it, and they could obviously see off the website. So I think it really has addressed all the concerns and is something that we really need to get fixed and clarified and cleaned up. But I'd be glad to answer any other questions about that. 48, 72 hours don't matter to me. If y'all think it's necessary for the 72, it's fine with me. But it was a good comment that they might need some flexibility to meet faster.
Vice Chair Busey?
Yeah, and I think you just said it, but I just want to get clarification, just so we're in line with the question with Secretary of State. You're okay. It's not your intent to say that all of the board members participating have to be in person. They would still be able to participate virtually like a sheriff or somebody else.
That would be fine with me, yes, and that's not our intent is to stop somebody from doing that. So certainly not have the idea of the public to watch this and be a part of it and see it is
but
what
some people could participate that way if necessary to be able to. Okay.
Yeah, just like we do here.
Thank you. Thank you, sir. Thank you, Mr. Chairman.
Mm-hmm.
Thank you.
And Mr. Vice Chair, if we have to clarify that, we could.
Okay. Representative Morales?
Thank you. Thank you, Representative. With respect to the notice of the current members of the board, this bill does not specifically provide for them to get notice, and I know that some of the concerns were that even members of that election board are sometimes not notified.
Well, I would think that, there's no way you could call a meeting and not notify. Well, obviously, the example was that the sheriff never obviously got notified in his county. But if obviously we're having a meeting, they have to be notified that they're there because they're on the committee. But if we need to add something to say you must notify everybody in the committee by letter or email, we can add that.
I would just add it based on the testimony that
I get you.
Consider. I like this bill. I understand the nimbleness that you're asking for the 48 hours. At one point, there was just consistency for me as a municipal attorney, like getting the 72 hours and just know that for almost everything there's 72 hours prior notice. But I can understand the need for 48 hours as well. And you've addressed my concerns over whether we needed to be more in compliance with like the Government Code 551 under the Open Meetings Act. But I think from the previous, your testimony as well as the previous folks that have testified, I frankly feel that they should be open and as much as possible.
Absolutely. This is the kind of committee that needs to be always open because this is what the people want to see and they're fearful of it. And as I said, it's illegal for us to do anything like that no matter what, right? So, this is not like we're asking them to do something that they don't. I can't swear the county, now, but I would imagine all county meetings have to be that way too. But
the county commissioners or court have to comply, and they are subject to the open meetings. And then there's a few exceptions where they can go into executive session.
Okay.
And so that's already, I think, there's enough protection there in place. So then, from what I understand, this board's just rubber stamping a lot of the prior decisions from the commissioners court.
Yeah.
Thank you, Mr. Paul.
Thank you, Representative.
Thank you, sir. Any other questions, members? Representative Paul, I mean, I think you've got a wealth of knowledge, and Representative Morales, and yourself and Ms. Atkins, and if y'all get together and kind of work on that so we can get...
Yeah, we'll make sure we don't want to cause a conflict, because this kind of stuff that we're trying to fix, right? No. We want to make sure that there's no unintended consequences and that we do follow all the law. And I don't want the Secretary of State mad at me either.
Well, I think it's a great bill, and I look forward to the finished product on it, and thank you so much for your time today.
All right, thank you with that, Chairman and members, and ask for your careful consideration.
All right, is there anyone else who wishes to testify on, for, or against House Bill 2800? Did I not do that before?
You did it before.
I did do that before.
Yes, sir.
Well, I'm having a bad day. All right, so anyway, no one else is wishing to testify on 2800, then Representative Ball, if there's no objection, we're going to leave it pending. And House Bill 2800 is left pending.
All right, thank you.
Thank you so much. The chair lays out House Bill 386 and recognizes Representative or Vice Chair Gonzalez to explain the bill.
Not the Vice Chair anymore.
Good to see you, Vice Chairman.
Thank you. Thank you, Mr. Chairman, members, for giving me the opportunity to lay out House Bill 386. This bill previously passed out of Elections Committee, believe it or not, unanimously last session. And I want to thank Representative Swanson, because we worked a lot together on the language on this bill to improve it. And I appreciate her support on this bill again this session. This bill, the Texas Elections Code allows an elections officer to deliver a ballot to a registered voter at a polling place or the curb if they are physically unable to enter the polling place due to a disability or health concern. Voters have expressed difficulties accessing their ballot at the curbside due to unclear instructions and inconsistencies. What this bill seeks to address the procedures an election officer follows by requiring a parking space at each polling place, and it be designated and clearly marked for voters unable to physically enter the polling place. The parking space designated under this bill would not be one that is already designated for persons with disabilities, or also known as a handicap spot. This is to ensure that disabled folks can still enter the polling place if they choose to do so, or if, say, the polling place is a library, we're not restricting access to the facility. When a voter requests curbside voting, the elections officers confirm the voter's registration status and identification. They deliver the ballot to the voter, and either the election officer or the person accompanying the voter will place the ballot into the ballot box. But just to be clear, I mean, this doesn't affect that procedure. This is like specifically for the designated space. But disability groups across Texas have reached out to our office in support of this bill. We must ensure that all citizens have access to the ballot, regardless of a disability or health status. But I know we have some witnesses here to testify, but if the members don't have any questions, I reserve my right to close.
Thank you, Vice Chair. Yes, sir, Representative Manuel.
Hello, Desmate, how are you? I have a quick question. Sure. This would designate a parking space for people who need this. This is correct, not handicapped though?
Correct.
Okay, perfect. Thank you so much.
Thank you.
Thank you, Representative. Any other questions? All right, thank you. The chair calls Alan Vera. Good afternoon, Mr. Vera. You're Alan Vera. You're here on behalf of the Harris County Republican Party Ballot Security Committee. Is that
correct? That's correct.
And you're on the bill?
That's correct.
Go ahead.
In 2018, the U.S. Department of Justice sued Harris County with the claim that our polling places were not ADA compliant. In 2019, Harris County signed a consent decree with the Department of Justice to comply with their directives. Everything that Vice Chair Gonzalez has in her bill is in the Harris County Elections Operating Manual and Training Manual to do it exactly that way. How's it worked out? Well, putting aside the technical issues like whether the buzzer or intercom actually work, or whether the election officer's cell phone has service at the time the voter calls, the main factor limiting the success of this effort has been the willingness of the facility manager of the building in which the poll is located to cooperate. The election code favors the use of publicly owned facilities for polling locations, but allows the use of privately owned facilities when needed. Over the last 3 election cycles, the facilities managers of both publicly and privately owned buildings in Harris County have refused to allow the election officials to block off extra parking spots to accommodate the disabled voters because it's not state law. They don't have to, okay? They don't want the election judges to add additional reserve spaces to the ones that are already marked in their facilities. This bill is prescriptive. It says an election official shall designate, etc. This means the election official is in violation of the code if he doesn't do that. But the reality is the election officials in Texas right now have no authority to overrule the facility manager and the parking lot at that location. The school custodian overrules election judges constantly. You might be able to establish a penalty for a facility manager at publicly owned buildings, but if you establish a penalty for facilities managers at privately owned buildings, all you're going to do is reduce the number of those buildings willing to host an election. We have a problem. As the bill is currently worded, it sets up thousands of election officials across the state for failure. They will not be able to comply with this new requirement because they have no authority to compel the facility manager at their location to comply. We shouldn't set up our election officials to fail. Thanks for the time. I'll be happy to answer any questions.
Thank you, sir. Members, any questions? All right.
I would like to ask a
I'm so
question.
sorry. Mr. Vera? Hold on just one second. I do think we have one.
Almost got away.
That's all right. Representative Swanson.
Yes, thank you, Mr. Vera. You bring up some points I hadn't thought about since, obviously I've been in support of this bill last time and this time, and
It's a good bill.
right. So
Can it be done?
can you, perhaps work with the author on things that might help? Perhaps a small building doesn't need additional spaces, but we heard complaints 2 years ago that people couldn't, as she said, couldn't go to the library because people wanting to use the facility for its normal purpose were not able to find a handicap stall because they were taken up by the voting handicap stalls. So I don't know if you could come up with some really creative thing that, depending on the usage of the building normally and whether, I don't know. I'm just asking if you
The
can.
most creative thing I can think of is a ball-peen hammer. Because the reality is, okay, there's nothing in the code. First of all, we're having a harder and harder time. Schools are publicly owned buildings. Schools are required to make their facilities open for elections. But across the state, I'll guarantee you, ask anybody from any county, the schools are resisting more and more. So we're going more to privately owned buildings for polls because the schools won't let us put polls there. And the privately owned buildings have no desire to comply and rearrange their parking lots to suit us. The schools should. So, Representative Swanson, I will definitely do anything I can to help, but it's going to require some changes to the code in other areas than the election code.
Which we might run into problems that we couldn't add that, might add a point of order. I just would ask you if you could think creatively, or anybody else in here has some great idea to get it to the author, because I would like to see this bill pass. I think it's got great intent.
I will tell you, I like this bill also, but I'll tell you there's bills moving through the Senate that indicate that a school facility that is denied to the county for a polling place cannot be used as a polling place for a future school bond with school board election for 5 years. That's moving through the Senate right now. We have to have some teeth to give Vice Chair Gonzalez's bill a chance to work. It's a good bill. The idea is good. The cooperation's not there from the facilities managers.
Perhaps something could be amended into a different bill, but
I think
if y'all
so.
could work on it and think about it, I'd
Sure.
appreciate it.
Thank you, Representative. Members, any other questions? Okay, thank you.
May I leave, sir?
Yes, sir.
Thank you.
The chair calls Veronica Warms. WARMS, I believe. Did I get that right?
You absolutely did, sir.
Are you Veronica Warms?
Yes, I am.
Are you here on behalf of the Texas Civil Rights Project?
Yes, I am.
Are you for the bill?
Yes.
Okay, go ahead, Ms. Warms.
Chair Smith, Vice Chair Busey, and members of the House Elections Committee. I am here today to testify in support of HB 386. At the Texas Civil Rights Project, we help run the nonpartisan election protection hotline 866-OUR-VOTE. Every election, we get hundreds of calls from voters with disabilities trying to cast a ballot, including many reports from voters across the state who report trouble with curbside voting access. This bill would require all counties to post signs informing voters on how to access curbside voting. Many voters in Texas do not know that curbside voting must be offered at every polling place. If there are no signs providing proper notification and instructions, voters with disabilities will not necessarily know that they can request curbside. Without signs, even voters who know that they can request curbside may not know exactly how to request it. Voters across Texas struggle with access to curbside every election. Our 2021 curbside voting report told the story of one of our volunteers who saw a voter in a wheelchair trying to enter a polling place that had no ramps or curb cuts. The polling place had no signs on how to vote curbside. Lack of signage was such a problem in 2020 that TCRP sought and won a court order requiring Bexar County to post curbside signs in conspicuous places at every polling location. The Texas Secretary of State's office already provides signs telling voters how to access curbside voting in English and Spanish. Requiring counties to display them would be a simple fix to a persistent and widespread problem. Curbside voting is a crucial aspect of disability access in Texas, and HB 386 would make sure that voters who need curbside are able to use it. We ask you to report this bill favorably. Thank you.
Yes, ma'am. Thank you very much. Members, any questions? Witness, thank you very much. Appreciate you.
Thanks.
The chair calls Kathy Hagler. You are Kathy Hagler, and you're testifying on behalf of yourself, and you're neutral on the bill, is that right?
Yes, sir, that's correct.
Okay, thank you. Go ahead.
Thank you, Chairman, Vice Chairman, members. I like this bill very much last session. I think it's really important to have a parking space that's not a handicap space, that is dedicated for curbside, because somebody hurt their foot, they're on crutches today, they just had surgery last week. They don't have a handicap designation on their plates or hanging on their mirror, but they need that spot. So I still can't figure out why this didn't pass last session, because it's a good bill. And it's such a good bill that my county is already doing it. And it's really very simple. A lot of times they're saying, well, there's nowhere to put the signage. Yes, there is. All it takes is a traffic cone with a little wooden stick sticking out of it with a sign that you have printed up that says to vote curbside, call this phone number. It's very, very simple. And we have it at all of our places. So we're already observing it in my county, and I think it works very, very well. So the only reason I'm speaking on the bill and not for the bill is because in Section A2, it suggests an alternative to displaying the phone number, and I think that the button or the intercom should be may additionally be, but I think that we need to require that the telephone number be there and not give them an option to not have that phone number. I don't mind the extras. I just want us to make sure we have the sign with the phone number and the instructions, because if a driver can't get into the polling place because of a disability, they may not be able to get out of their car and get to the button. And even if you drive up to it and the button's right beside where you drive up, you're still going to have to put a sign on it to tell you what it's for. So on that sign, why don't we go ahead and put the phone number? So I just think that there would be no instance where we wouldn't have a phone number. I know what some of the hesitation is about that is because if a election judge is given one phone, they're usually on the phone more than half the day with the voter registrar trying to find out if somebody's on the rolls or not. They're using that phone, and so the person at curbside can't get through. And so maybe the way to fix that is to have a second phone, one that's dedicated solely to the curbside voter so that it can't be tied up with the presiding judge on that other number. But of course, if we make it to where you had to have the buzzers and intercoms, now you would be getting into a fiscal note because those are expensive to install. So if we just made it to where the phone number is mandatory and the other part is optional, I could completely support the bill.
Okay. All right. Well, thank you. Members, any questions? Ms. Hagler. All right. Thank you so much. The chair calls Molly Broadway. Hello, Ms. Broadway.
Hi, how are you?
I'm well, thank
Good.
you. Good afternoon. You are Molly Broadway, is that right?
That's me.
You're testifying on behalf of yourself, is that?
Yes,
And are you for the bill?
I am for the bill.
Thank you. Go ahead.
Yeah, so I actually, this bill, as you'll see, is in memoriam of an individual named Garrison, and she was a lifelong and tireless disability rights advocate amongst, generally speaking, she just wanted everybody to be treated the same, no matter what. I worked with Ms. Garrison on curbside voting quite often in a professional stance. In honor of her, I think making curbside voting signs is the very least we could do for all the work that she had done through her life to make voting and civil rights more equitable for everybody. I will say that this bill in itself aligns state law with the already existing ADA guidelines. Curbside voting is required at every polling site in the state of Texas, but signs are not. ADA best practices say you need a sign, like everybody's been saying, to designate a parking space and also to have a means of contact for the poll workers who are working inside the building. I think this law also provides a resource for reoccurring election issues that currently has no guidance. It comes up quite often. What am I going to do if I need to go vote curbside? Who do I call? Where do I go? This actually provides some concrete guidance on that, aside from calling all the support agencies that exist for voter rights and the county elections office itself. It probably will free up their voting or their phone lines some as well. I am also in support of the part of the bill that talks about having a call button, because to take into consideration if a voter does not have a phone, how are they going to call the phone number that's listed, if that's the only ways of contacting election staff? And then also if that person does not speak the language that the poll worker speaks, how are they going to communicate that as well? So a button would make it easy. And so there you go.
Okay, well, thank you so much for your testimony. Any
Yeah.
Members, any questions? All right, thank you.
Thanks.
Ms. Carranza, the chair calls Susanna Carranza. Or Dr. Carranza. Susanna Carranza, you're here on behalf of yourself, is that correct?
Yes.
Are you for the bill?
Yes, I am.
Go ahead.
As I mentioned before, I'm an election judge and I work as a deputy in early voting. And I like this bill because some of the concerns raised that, there are some polling places that may not really have obvious for the voter how to get. I had people that really kind of came, like one of the other testimony mentioned, like, struggling to get through because it wasn't obvious they could do curbside. And also, we live in Texas. It gets windy sometimes. And, getting the signs up, like you kind of have to make sure the signs are nice and robust because otherwise you have signs on the floor that are kind of useless. I do agree, I didn't think about it before, but I do agree with the comment that it is definitely helpful to have both the phone and a button type of scenario because without the phone number, it might be hard for some people to reach a button, but if a person doesn't have a phone or the phone battery died or whatever, it's helpful to have another means. Anyway, that's thank you for a good bill.
Members, any questions? Doctor, what kind of doctor are you?
I'm a chemical engineer.
You have a PhD in that?
Yes, from UT.
Oh my, okay, all right, well, thank you very much. Appreciate your testimony. I mean, Vice Chair Busey.
Mr. Chairman, it's the doctor's birthday today.
Dr. Carranza, is it your birthday? Well, happy birthday. Just to save everybody from it, we won't sing happy birthday. But yeah. Well, happy birthday. The chair calls Rosemarie Clouston. Did I pronounce that correctly?
You did, Clouston, but close enough.
Clouston?
Yes.
Okay, you're Rosemarie Clouston, and you're testifying on behalf of yourself? Is that
That's
right?
correct, yes.
And are you for the bill?
Yes.
Yes, ma'am. Thank you. Go ahead.
Good afternoon, members of the committee. While I am testifying for myself, on behalf of myself, I speak from the experience of being the voter protection director of the Texas Democratic Party for the previous 3 years and overseeing our voter assistance hotline. So most of my comments very much echo Veronica and the Texas Civil Rights Project's experiences because this is a nonpartisan issue. Voters of both parties, all parties, and no parties experience these challenges where we often get a number of calls from voters where they are trying to go to vote, they need to vote curbside, and they aren't sure of those procedures. And so one of the challenges is that we can't tell voters all across the state what the procedure will be and how they will be able to access curbside voting. And so this sort of consistency that this bill brings and allowing voters all across the state to have the same opportunities and the same knowledge and confidence in this process will be helpful to a lot of us organizations that do voter education and try to make sure that voters know what their options are and how to take advantage of those when they need to. Additionally, the other challenge that we see is sometimes allowing voters with one type of disability or accommodation need to access that at the disadvantage of others, right? So voters who need curbside voting taking a parking spot from the disabled parking spot, for voters who are going to go inside of the building, for example. That sort of trade-off when it can take curbside voters, a half an hour sometimes to utilize that process because of other internal challenges at the polling place, that can really tie up those parking spots and create those trade-offs, especially at our small polling places that may only have a couple of disabled parking spots. So this, by adding the additional parking spot for curbside voting, will ensure that voters who are going inside to vote don't suffer because of that, because there's someone curbside voting or don't have access to get inside the building as well. And then the other thing is that we see a lot of times because that curbside voting isn't clearly designated, someone just pulls up front and then they're blocking the curb cut, right, where a voter who uses a wheelchair or other mobility assistance device needs to access that building, whether for voting or to go into the library, like others were saying. So I think this bill will really help address a lot of those challenges and make it more accessible. The other thing that we hear is that voters are going independently, right? Someone has a disability, they're going to the polling place independently, and they want the ability to let the location know that they need curbside voting. Right now, they're in a position sometimes where they have to try to flag down a good Samaritan and say, hi, can you tell someone inside that I'm here and I need help? And that's not respecting the dignity of the process for them, and they deserve this access. So thank you.
Yes, ma'am. Thank you very much. Members, any questions? Yes, sir.
And it's a question, but kind of want to echo. So it also puts, if you're a candidate and you're there, and you're wearing your campaign shirt, you can't go in with that shirt on. Mm-hmm. And sometimes people, I would say more of a question, have you seen people wait in excess of 10 to 15 minutes just to see if someone can go inside to let them vote?
Absolutely. And to your point, a lot of times the people who are there too, that might be willing to help, are folks who are there on behalf of a candidate or party, because those are folks hanging out outside. And then, we try to guide them of, okay, ask that person to put on a jacket and go inside and stuff, but it can be quite the ordeal. And this is more respectful of that person's dignity and autonomy.
My shirt was the one that said, y'all are crazy, but I don't have one anymore. Thank you so much.
Absolutely.
Thank you. Members, any other questions? Okay, thank you so much. I'm going to try and get this right. The chair calls Phalaris Hollins. We'll never know if I got it right.
She's coming.
Oh, is she coming?
Yes, sir.
Okay, thank you. All right, we're going to wait just a minute. Okay, thank you. Yeah. Thank you for being here, Ms. Hollins.
Hello.
Hello, did I pronounce your first name correctly?
Kind of, sort of, but not really.
Go ahead, tell me
It's
what your name is.
Valeria Hollins.
Valeria Hollins?
Yes.
Okay.
No, thank
you. Let's see, how do you spell that?
Phaleria.
All right.
Valeria.
I just want to make sure we've got you correct in here.
Okay.
Ms. Hollins, you're testifying on behalf of yourself, is that right?
Yes.
And you're for the bill, is that
Yes, I am.
We have her in there correctly?
Yes, I just correct the spelling of your name in there, so.
Okay.
All right, thank you so much. Go ahead.
Okay. And I'm speaking on behalf of the affirmative of enacting House Bill 386 for accommodating a voter unable to enter polling place. As a friend, colleague, and associate of Kate Garrison, this bill will commemorate her legacy of hard work and dedication to removing barriers and bringing awareness to accommodations with people with disabilities. In 2017, in partnership with Disability Rights Texas, other coalitions of nonprofit and nonpartisan advocacy groups, and Collin County, our project was selected as a winner of an Election Assistance Commission Best Practice Award. It is known as a Cleary Award for improving voter accessibility. And as a result of Kay Garrison's visions and determination, streamlining processes to ensure that if a voter was physically unable to enter polling place, they could have a ballot brought to their car to vote at curbside. Today, as a volunteer, these best practices are still being used to improve services for voters with disabilities. And I will say, for example, in the 2022 election season, myself and volunteers performed curbside voting reviews in addition to Collin County, we did it in Russell County and in Dallas County. And our study uncovered that how the regulations vary from county to county. The recommendations from our review of the curbside voting process were aligned with the House Bill 386 for access to curbside voting. And some of our recommendations from our project in 2020 were as follows, like a designated parking space at each polling for curbside voters. The second one, this parker should be in addition to the accessible parking space already set up, not to interfere with any customers that are, like they were said earlier, going into a library. And so this separate parker does not interfere with the customer's businesses. Standardized parking identifies curbside voting instructions. This specifying like letter sizing and distance from the curb, this would eliminate the subjective use of this bill and the wording. The next recommendation that we had was prohibiting restrictions of the view of the curbside voting sign. What we uncovered at one polling location in Dallas County was that a curbside voting sign was available, a curbside voting sign with the number and everything was available. But as a reviewer, when I pulled up to access the information on the curbside sign, the signage was covered with polling information and other information relevant to voting. And the telephone number on the sign was small. And so from the curbside, it was ineffective because you couldn't read it or you couldn't see it. And so that example, I did call Protection Hotline, and the response to me was, unfortunately, that sign is illegible and it's really not usable. However, it is in compliance with the law that it required a sign and it required a phone number. So improving those accessibility issues are just the small things that could help. And the last one is a clear instructions, including a phone number for that voters may use to request assistance from an election officer. And one last example of a person that uses curbside voting. I went to a location in Collin County. It was a perfect, they had a sign. They had a sign that you can use. It was visible. I was perfect. I used the curbside voting and was excited to do so. However, at the very end, after I voted, they gave me my paper ballot, and the judge asked me, okay, now, are you going to walk this ballot into the polling location to drop it in the box? And I thought for a minute, I've curbside voted. I can walk it in. But your question was for me to walk that in. So with this affirmative on HB 386, it also will give education to the election judges and anyone else, because it's the small things of the people that use the curbside voting can change it and enact it and make it better for everyone in the state of Texas to use curbside voting. Thank you.
Thank you so much for your testimony and your work in this area. Any members have any questions? Ms. Hollins? Thank you very much.
Thank you.
The chair calls, let's see, Kimberly Wilson Vibert.
Good afternoon.
Good afternoon.
My name's Kimberly Wilson Bibbert.
Yes, ma'am.
Yes, I was wanting to testify for the House Bill 386.
I appreciate that. Can I ask you a couple of questions? Just
Sure,
real
yes,
quick,
you may.
so we can make sure this is all on the record?
Sure.
Are you testifying on behalf of yourself, ma'am?
Yes, I am.
And you're for the bill, is that correct?
Yes, I am.
All right. Thank you so much for being here. And go ahead.
Okay. I wanted to testify for this bill because I have had some of the experiences of trying to use the curbside voting where I get there and the sign isn't clear or legible, and where the phone number was kind of covered or mislaid on the ground. And so I had to, at the time I was able to walk to it, lift it up, and find what I needed to, and work it and use it. But then again, most times it's not always like that. Normally, like in Plano in general, big towns, the bigger cities in Collin County, yes, I can see it. But in the smaller towns, not as much. And so I was thinking of, for us to be able to make it more prominent, like on A-frames, where people can see mounted on there in about cardboard size in block letters, as in to call this number when you need to have someone to come to you when you need to curbside vote. The other part is that unfortunately some diseases are a combination. Like for me, it's walking and being able to stand. and be able to see. So if we can have things where there's no set line as into how the disability is going to come out, because you can say it's this disease, multiple sclerosis, what I have. Yeah, it has a few other things attached to it. And how it hits me is not going to be the same way it's going to hit someone else with MS. So, and it's for a variety of diseases, but I would like to have us to be able to have a broad range of tools that allows people with a disability to be able to access and also bolster and broaden how many different tools are available, because what I would need may not fit for someone else with their disability and their immune compromised state. Also, I think it would be also good to educate and advocate not only for ourselves and for the poll workers, but also for the judges, so they understand that this person with this sort of disability has this, but it may not mimic the same way that someone else has that same disease. And so it would be better to have a wide variety in educating and advocating, follow the constituents within that area and ask them in person, what's your problem with, have a talk with them and say, I have problems with these few items, or these are the few items that I'm having problems with that won't allow me to complete the ballot on paper or be able to see it on this touch screen. It'd have to be shrunk or lowered or alteration of color, because before I used to I couldn't see red, green, or blue. So that would be something that should be included within the polling places where things can be altered according to that voter. At that time, they need to go vote. But those are the things or aspects that I'm seeing about trying to use these voting places, these facilities, in order to submit a vote. Because like I said, we all have fingers and toes, but there are a variety of diseases that could hit someone in a variety of different ways, and it's not going to be the same for each person. And that's what I would like to have this bill go through, is to be able to help people like Kate Garrison did when she started this, and for other people who may not have a disease today, but who knows how they'll be tomorrow. And that's my main point of the Kate Garrison bill.
Thank you so much for your testimony. Members, any questions? Ms. Wilson-Bibbert, did I get that correct?
Yes, you did.
Okay, wonderful, wonderful. Did you come here today from Plano, Texas?
Yes, I did.
Thank you so much for making the effort to come down here. I think our previous witness also came from out of town. We appreciate y'all making the effort.
Thank you very
Thank you so
much.
much for taking part in the process.
You did.
The chair calls Christina Atkins. Ms. Atkins, you're testifying again on behalf of the Texas Secretary of State, and you're on the bill as a resource witness, correct?
Yes, sir.
I've got a question. You've heard some of the testimony, and I think you may be familiar with this bill from the last time around.
Yes, sir.
I didn't see a fiscal note on it, although it does say that there could be some expenses for the counties. Do you have some input on what kind of technical burdens or requirements we may be looking to add to implement this bill?
I think that's an excellent question. From the state's perspective, there's no impact. For us to prescribe some signs and revise our training materials, those are all things that we can do very easily. As far as our local government potential impacts there, one thing I noticed is that there may be maybe a small impact in the sense that some of our local counties are going to have to procure some signage or maybe possibly procure some supplies to assist with this. But I do notice that the bill provides options in here for providing that notification, and so that gives our local governments and our local election officials the ability to, look at what their budget allows for and gives them various ways to meet that. So I'm sure there's some cost-effective ways to do that.
Okay. Thank you very much. Members, any questions? All right. Thank you so much.
You're welcome.
Chair calls Ed Johnson. Mr. Ed Johnson, you're here on behalf of yourself, is that correct?
That is correct.
And you're against the bill, is that right?
That is correct.
Okay, go ahead.
Yes. I would say, if we're talking about this bill is referring to somebody that travels to a polling location and is unable to get out of the vehicle they travel in to let somebody know they need curbside voting and is not assisted by anybody. If we really want to help this voter, we'd have money better well spent on assisting them in registering to vote by mail. If I had a loved one or a family member that was unable to get out of a car, I'm not going to put them in a car and send them down the road and something happened to that car and they're not able to help themselves. That's not a safe situation. These people would be better served by voting by mail, and they all qualify automatically to vote by mail. If you're handicapped, you qualify automatically to vote by mail. It'd be a lot more better spent on the funds to assist people to vote by mail instead of trying to jeopardize them in traveling to a polling location, which they could get in trouble with if they're not able to get out of a vehicle. Because that's what this bill's referring to, is somebody that's not able to get out of a vehicle. Now, on the financial end that you were talking about, Chairman, this would be a great financial impact to a county. The doorbell buzzers, they're $1,000 a piece. By the time you get the buzzer, the receiver, the case that it goes in, it adds up to $1,000. You need 2 of them per polling location because you normally have redundancy in case something fails. So that's $2,000 per polling location just for the doorbell buzzer. You're asking an election judge who, by law, we can only pay 1 hour's worth of time in setting up a polling location before an election starts. That's in election code. They only get paid for 1 hour to go out and now become the, parking lot manager that's going to draw off an ADA parking space and put up signage in their 1 hour while they're also setting up election equipment beforehand. So you're going to have election workers that aren't going to get paid for work that they're doing with the current election code because they can't get all that done in an hour. You can't do that. November is a very stormy time of the year sometimes, cold fronts. The signage that you would have to stay up in a cold front coming through with a heavy rainstorm is pretty significant. I mean, that would cost some money. I can tell you on the sign with the phone numbers. Not all counties provide election judges. In fact, very, very few counties actually provide election judges with cell phones paid for by the county. And I know that my wife's an election judge. She doesn't want her cell phone pasted in front of the business or whatever on a sign. So now you're going to require counties to purchase cell phones for all their election judges and provide a number, which is a very expensive process. This is several $1,000s that you're putting into a polling location for this requirement. It's definitely in the unfunded mandate category to the county. And the simple answer is, and the more safe answer for the voter, is assist them in voting by mail. Help them vote by mail. If they want to come to a polling location, hopefully they can have a friend or somebody that could take them to a polling location to do it. But if they're unable to do that, let's keep them safe and assist them in voting by mail.
Thank you, sir. Vice Chair Busey.
Thank you, Mr. Chairman. Mr. Johnson, I just want to push back a little bit because I think what this bill is trying to do, and we've heard from other witnesses, is maintain dignity for voters. And you're right, voting by mail is an option. We've made it significantly harder, as we've seen in the stats that throw out more and more ballot by mail last session. But this is about dignity. If we want to be a state that increases access to all voters, this is so someone, if they want to vote in person, could still have that option. I think one. Two, just a quick Amazon.com search, I'm seeing doorbells that you refer to for $17.99 and $26.60. So I just feel like, I agree with you, it will add costs. We're talking about everywhere. But for that cost, I think that's the price to pay to maintain dignity for the voters. And I guess if this is a question, I would say, do you disagree with that?
Well, let me refer to that. Yes, you can Google on Amazon and you see doorbells for handicap. And those for businesses. But if you're talking about a government entity, it needs to be ADA certified if your county is going to be using it. And the button has to be a certain size. The transmission range has to be a certain distance to be on the ADA qualify. The sign has to be in a certain fonts, and the stand has to be a certain height. So there are only two companies that make those buzzers, and they start at about $650 a piece just for the buzzer. Then the transmitter is another $100. The cases are $100. The sign then is an additional cost too, about $100. It's expensive when you actually have the ADA certification stamped on it. And if you want to be legal with your county, you're going to have to be using ADA certified materials there.
Okay. Thank you, Mr. Johnson. Members, any other questions? Thank you for your time.
Thank you.
Yes, sir. The chair calls Mark Hoskins. Good afternoon, Mr. Hoskins.
Good afternoon, Chairman Smith.
Would you state your name for us, please?
Mark Hoskins.
Are you here on behalf of Disability Rights of Texas?
That's correct.
And are you for the bill?
Yes, sir.
The chair would recognize that Chairman Capriglione is with us. Go ahead.
Thank you. So to be very quick, Disability Rights Texas supports House Bill 386. This bill is beneficial to both the voters and the election staff to have clarity in the code with the requirements of signage, the access to the service, as well as the designation of the parking spot. And simply, I request your favorable consideration for this bill. And I want to thank Representative Gonzalez and her staff for reaching out to us and working on this bill.
Yes, sir. You heard the testimony from Mr. Johnson. Do you share any of those concerns?
There are ADA requirements, but I think with this bill, I don't think that any of the ADA requirements would prohibit this bill from becoming law. And this actually would make us, the state, one step closer to being in compliance with the ADA.
Okay. All right. Thank you so much. If there's no other questions, we appreciate you very much.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 386? If not, the chair recognizes Vice Chair Gonzalez to close.
Thank you, Chairman, members. So I just wanted to clarify, just from some of the testimony, that this bill does not create an additional parking spot. Like, you do not have to use your current parking space. It's already in a parking lot. No, we're trying to avoid that, because I understand that there are some polling locations that have very limited parking spots. And so to ask somebody if they already have a handicap spot that's already there for folks that are, let's say, visiting the library, this just creates an additional area. It can be on the curve, it could be at another space in the parking lot that is specifically designated for this, right? And so I just wanted to make that clear, because I think that folks have said that now we're having to block off more than one spot. That is not the case here. In working on the language in this bill last session with Representative Swanson, we created that alternative to do to the cell phone, and then the alternative do a button, just because we took from the feedback that we got from folks. Just some polling locations just don't have the flexibility. They don't have enough workers there to dedicate one single line, right? Or if you're trying to call, you can't get through. So another option would have been just buying like one of those wireless doorbells, and you have that, they have that there. That way somebody can get somebody's attention from the inside if you can't get through. And, as mentioned, the cost of that would not, aren't very high. I mean, you can get, a wireless doorbell fairly cheap online. And it would be used only during the time that we're having elections. At any rate, this bill would ensure that there's uniformity statewide. I mean, you heard from the testimony that there's certain counties that are already implementing this and very successfully, Collin County being one of them. And so, this would ensure that there's a standard for curbside voting for folks who are eligible to vote curbside. And I would respectfully ask for your favorable consideration on this bill. And if there aren't any questions from the members, I close.
Thank you, Vice Chairman. Members, any questions? Okay, thank you so much.
Thank you.
If there's no objection, House Bill 386 will be left pending. The chair hears none. House Bill 386 is left pending. The chair lays out House Bill 2629 and recognizes Representative Rogers to explain the bill. Good afternoon, Representative.
Thank you, Chairman Smith and members. Thank you for the opportunity to lay out House Bill 2629. House Bill 2629 is a bill to provide greater transparency in state elections, particularly from political organizations that spend money independently to oppose candidates for office. Under current campaign finance laws, PACs are required to disclose the names of candidates they support, as well as those they oppose. However, these cover sheet disclosures do not indicate the amount of that support or opposition. In a separate schedule of the campaign finance form filed with the Texas Ethics Commission, a PAC that makes a direct campaign expenditure, also known as an independent expenditure, to support a candidate without the candidate's knowledge or consent, is required to provide, in addition to the amount, purpose, and payee receiving the expenditure, the name of the candidate who benefits from the expenditure. There's a long sentence with it. However, PACs are not required to list the name of the targeted candidate if they make an expenditure in opposition to that candidate. And that's a very important point. They're not required to name the targeted candidate if they make an expenditure in opposition to that candidate. As a result, candidates in Texas find themselves on the receiving end of thousands of dollars worth of mailers or other forms of political advertising against them, without the candidate or the public being able to discern the amount being spent, as would otherwise be the case if it were the candidate's opponent making the expenditure. HB 2629 would require the name of each candidate or office holder for whom a direct campaign expenditure was made to oppose during the reporting period be listed with the relevant expenditure. So the trade-off for Texas unlimited spending in political candidates has always been transparency and accountability. This bill simply ensures that where appropriate, persons and PACs who make direct campaign expenditures are as transparent as the candidates they work to support or oppose. I'm happy to take any questions, and I respectfully request the right to close.
Thank you, Representative. Members, any questions? Representative De Ayala.
Yes, Representative Rogers. Earlier you mentioned that PACs have to name candidates they oppose. Why is that? Why is that necessary?
Well, it's necessary. They name the candidates they oppose, but they don't tie the expenditures to that candidate. And the reason that's necessary is because in a campaign, just give you a hypothetical situation. Let's say a candidate reports they spent $500,000 and another candidate spends $1.5 million. Okay. Well, that candidate that spent $500,000 also may have had $1 million spent against his opponent, but there's no way to tie that money to the candidate. So this would tie money spent in opposition to the appropriate candidate.
Thank you very much. Any other questions, members? Thank you, Representative. I think we have one witness registered. This time the chair would call Ed Johnson. Mr. Johnson, you're here on behalf of yourself and for the bill, is that correct?
That is correct.
Go ahead.
Yes, the other one I've seen happening is in propositions or charter amendments, whatever that you have. And we have fixed one of the problems where they use reverse negatives in the language. Well, then you have a action pact or committee that's, saying they're against the bill to vote for it. We fixed the reverse negative, but this also would fix the funding in it. So it's a great bill.
Thank you, sir. Members, any questions? Thank you, Mr. Johnson. Appreciate your time. Anyone else here to testify on, for, or against House Bill 2629? If not, the chair recognizes Representative Rogers to close.
Thank you. I agree it is a great bill. It will enhance transparency by ensuring that PACs are held to the same reporting standards as individuals. Mr. Chairman and members, thank you for your time and ask for your favorable consideration of this bill. Thank you.
Any questions? All right. Thank you, Representative Rogers. If there's no objection, House Bill 2629 will be left pending. I hear none, so House Bill 2629 is left pending. At this time, the chair lays out House Bill 2351 and recognizes Representative Vo to explain the bill.
Thank you, Mr. Chairman and members. This is a very simple bill. Volunteer deputy registrar certificates expire on December 31 of every even number year. Renewing certificates require recompleting training upon expiration of each term, which may lower the number of active voter registrars in Texas. House Bill 2351 would require voter registrars to inform volunteer deputy registrar no later than November 30th of an even number year that the term of appointment expire December 31st of that year. The notice would have a renewal application and information about changes in election law. If completed, the volunteer deputy registrar would be reappointed without the need for training. With that, I reserve the right to close, Mr. Chairman.
Members, are there any questions? Hearing none, we will move on to testimony, and we reserve your right to close. The chair calls Andrew Eller. And Mr. Eller, just to confirm, you are here representing the State Republican Executive Committee, SC24, the Republican Party of Texas, and self?
Yes, that is correct.
And you are against the bill?
Yes, that's correct. I am against the bill.
All right, thank you. Please proceed.
Okay, I have 27 years experience as an election judge, mostly at poll sites, also in Central Count. I'm also an experienced poll watcher and a past volunteer deputy registrar. I'm against this bill for a couple of reasons. The first one is we typically require our judges and clerks, and now even our poll watchers as of the last legislative session, to go through periodic training for each of the election cycles. That's important because things do change. And why do we want to stop doing that with our volunteer deputy registers? Because they are an important part of our election process as well. So if we stop training those folks who have done it once before, why don't we just stop training our judges and clerks? It doesn't make sense. And you have to remember that as election law changes, and it typically does change just about every legislative session, we will see changes in the registration cards, the registration paperwork, and without some of these folks going through an actual class, by signing off on a piece of paper that says, yeah, I did read that and I understand that, that doesn't necessarily mean that they really truly understand it and can do the work. As someone who does training in the corporate world quite frequently, we see that there are many different types of learners out there. There are people who could read an affidavit and say, yep, I get that, I understand it, and they would actually be fully understanding of the changes in the law to be a volunteer deputy registrar, but there are a lot of folks who do not. We see a lot of folks who are auditory learners, and we see a lot of folks that are kinesthetic learners, and those types of people you have to bring back in. So there's no way to know what type of person that is that's been a voluntary deputy registrar over the years. So it's extremely important to bring them back in and go through the training for the same reasons we do it for judges, the same reason we do it for clerks, and the same reason we're doing it for poll watchers now every election cycle. So for those reasons, I'm against the bill, and I ask that you just let it die in committee. Thank you.
Members, any questions? Thank you, Mr. Taylor. Next up, the chair calls Alan Vera. Mr. Vera, just to confirm, we show you registered as Alan Vera on behalf of the Harris County Republican Party Ballot Security Committee, and you are against the bill. Is that correct?
That's correct.
You may proceed.
Mandatory state poll watcher training was required by Senate Bill 1 in the last session. 2022 was the first full year that requirement was in effect. Poll watchers in 2022 had to take the class twice because the Secretary of State offered the class twice with changes in each section. There was a class offered for the primaries and a class offered for the general. The Secretary of State did not simply send a certificate renewal notice to each poll watcher with a list of new issues contained in each of the many election advisories issued by the SOS during the interim. That's because the SOS knows that unless the applicants go through the training course, they probably won't read and comprehend all the new issues in effect. Volunteer deputy voter registrars should be treated no differently than poll watchers. You're making changes to voter registration procedures this session. The SOS is going to issue election advisories on voter registrations to explain what's changed and what needs to be tightened up. It's naive to think that, one, all 254 voter registrars in the state will accurately summarize all the changes in perfectly understandable text, and naive to think, two, that tens of thousands of deputy voter registrars in the state will actually read and actually understand those changes. I agree. I've read the terms and conditions of my iPhone software update. Right. Here I go. But that's exactly what this bill asked you to believe. It asked you to believe that in November and December of this year, without training, these tens of thousands of deputy voter registrars across Texas will read and fully comprehend what 254 different local voter registrars have written, and that they'll be ready to accurately carry out their duties for the 2024 election year without training. We don't need less election training in Texas. If anything, we need more. We ask the committee to reject a bill that lowers the training requirements for deputy voter registrars. Thank you for the time.
Members, any questions? Thank you, Mr. Vera. Next up, the chair calls Kathy Hagler. And Ms. Hagler, to confirm, you are Kathy Hagler here on behalf of yourself, and you are against the bill.
Yes, sir.
Please proceed.
Thank you, Mr. Chairman. I'm concerned about a couple of things in House Bill 2351. First of all, it should be the responsibility of the volunteer registrar who takes the action to renew their own status when it expires. The training very specifically teaches them when their status expires, and it's usually also on the tests that they take in order to get their status. So rather than asking the county voter registrar to spoon feed the deputies, I think that we should have the deputies take the initiative to renew their voter registration, their status. If you look at the bill, it also has the renewal form, and it says that it's determined by the registrar, which I have a real problem with because I can see 254 different kinds of forms. I believe that that should be corrected to be a form standardized by the Secretary of State so that all counties are using the same form. And then information about changes in the law should be included in training, not in a letter, as we've already talked about in other testimony. And as mentioned, poll watchers and election workers do have to renew their training, and the volunteer deputy voter registrar should be renewing their status by signing, or should not be renewing their status by signing a form instead of taking that training again. The training should be taken again for every renewal of their status, specifically to cover any changes in laws or procedures and as a general refresher course. Being a deputy volunteer voter registrar is an important civic duty, and taking a test for renewal of status is not too much to ask. I think we should promote more personal responsibility with our volunteer deputy voter registrars and not waste the voter registrars' time and taxpayer money to chase after them. And just like all the other participants in the election process, more training and refresher courses are a good thing. So I ask you not to forward this bill.
Thank you, Ms. Hagler. Members, any questions? Thank you. Chair calls Elizabeth Miller. Elizabeth Miller? Okay, not responding. The chair calls Chris Davis. Afternoon, Mr. Davis.
Afternoon, Chairman, Committee.
You are Chris Davis, is that correct?
Yes, sir, I am.
And you're here on behalf of the Texas Association of Elections Administrators, is that correct?
Yes, sir.
And you're for the bill, is that correct?
That's correct. We are for the bill. Thank you, Chairman, Committee members. We're touched that some of the previous testimony givers are concerned about voter registrars' time and how well it's spent. We can attest to this bill. I remind the committee is a permissive bill. I don't think any of the previous testimony givers mentioned that. It allows voter registrars, all 254 in Texas, to choose and use their discretion of whether they can actually exercise their discretion under this bill to convey changes in processes, the myriad changes of voter registration rules in writing. They can even do that in writing in multiple languages. Those languages can be committed to documents that can be mailed or emailed to the prospective VDR for renewal. It's a lot harder to have given in-person training and doing it in the languages that the voter registrar feels they need to for those VDRs in their county. Again, this is permissive. We like that we're able to convey updates and processes. And if there's a VDR that isn't giving great, or their office, or excuse me, it's their voter registrar that's not giving great training in person, that'll probably convey over to the written. So, I mean, the nature of the method that training is given, I don't think affects the quality of the training. It's all about the trainer and not the method. That's all I have. I'm happy to answer any questions.
Okay, thank you so much. Members, any questions? Thank you.
Thank you, Chairman.
Absolutely. The chair calls Dr. Susana Carranza.
Hi
Good afternoon. Dr. Carranza, you are Dr. Carranza. You're here on behalf of yourself and you're for the bill. Is that correct?
Yes, absolutely.
All right, thank you.
As you may or not remember from the previous testimony, I'm a volunteer deputy registrar. And in fact, I'm a volunteer deputy registrar for a lot of counties surrounding Travis because this is a big county. We get people from all over. One of the issues that we have is like each county has slightly different rules of when they can have stuff happening. So sometimes there's a gap early in the news cycle, which means that for that time, a VDR cannot help anybody. And, we have elections all the time in Texas. That can be a problem. The whole concern about, different types of training, yeah, it's true. Different people learn different ways, but they will learn whatever way makes sense to them. Also, having the ability to just renew makes life a lot easier for folks that become VDRs in many counties. Most people that become VDRs are dedicated volunteers that the last thing they want to do is make mistakes in somebody's registration. It is really a unique group of people, like, poll workers, and they would not just willy-nilly become VDRs just for fun. It's like it's time, it's effort. It actually costs us money because, you're doing this out of your own will and heart. I fully support this bill. Thank you, and I really, if we could make it easier on VDRs, I would. Thank you.
Thank you very much. Members, any questions? All right. Thank you so much for taking the time. The chair calls Rosemarie Clouston. And she's not here? Okay. Rosemarie's gone? All right. The chair calls Valerie DeBille. Good afternoon, ma'am. You are Valerie DeBille, is that correct?
That is correct.
You're here on behalf of the League of Women Voters and yourself, is that correct?
That is correct. The League of Women Voters of Texas, to be specific.
Texas, yes, ma'am. Sorry.
That's going to be irrelevant in a second.
Absolutely. And you're for the bill?
Yes.
Okay, go ahead.
I would like to add to that introduction that we are in support of HB 2351. And although I'm not officially representing my local league here today, it is relevant to my expertise on the subject that I am the current Director of Voter Registration for the League of Women Voters in the Austin area. And since 2018, I have personally registered more than 2,500 voters in more than 20 Texas counties in which I am currently or have previously been a volunteer deputy registrar. As Susanna mentioned, because we're in Travis County, there's a lot of people who come here from a lot of other places. We also do naturalization ceremonies where they just get told to come here. And it doesn't really matter where they came from. So we have people from as far as Bexar County and as far as Hill County. We've had people from Gillespie County, which is where Fredericksburg is. In Texas, a significant barrier to voting is the voter registration process itself. While we would prefer online voter registration to address this barrier, short of that, we support making it seamless for volunteer deputy registrars to renew their certification. From now on, I'm going to call them VDRs. They're a large part of our league's volunteer base. As VDRs, we register voters in high schools, movie theaters, farmers markets, and many other places voters frequent. VDRs also register voters after naturalization ceremonies, helping new citizens to get ready to exercise one of the United States' most cherished rights, the right to vote. VDR certificates are valid from the day of appointment through the last day of the next even-numbered year. For instance, all VDR certifications for the 21-22 cycle expired on the 31st of December 2022. Once the certification expires, a VDR cannot register any new voters until they are certified for the new cycle. Allowing VDRs to renew their VDR certification via email at the end of the 2-year cycle would reduce the burden on individuals who would like to continue to volunteer to register voters and would improve VDR retention rates for counties. In my experience managing VDRs in large numbers, many VDRs do not know that their VDR certification expires at the end of an even-numbered year. Even if it's mentioned in the training and the documentation, many of them took the training at the beginning of it 2 years prior. And so they have not been reminded recently. I usually end up having to check everybody's VDR numbers against the current system that the county is using. Like Williamson and Hayes, for example, use the last 2 digits of the first year in the cycle. So during 21-22, your number would have been 21-something. Now it's 23-something. And I have to double check with a lot of VDRs and make sure that their numbers are actually starting with 23 now, because they don't realize, because they haven't been told recently, and they're just getting email from me. So having another thing from the county that backs that up would be great. Many counties also require VDRs to appear in person at the county elections or voter registration office. Some counties offer classes, some have self-guided training options followed by a test, and many require an appointment. This process is burdensome to individuals who want to register voters in more than one county. As I said, I'm certified in 15 different counties right now. That's a lot of driving and a lot of gas money for somebody who does this as a volunteer. It would also help address the delay in certifying VDRs at the beginning of the year. At the beginning of this year, there was a 1 week long mandatory Secretary of State training for every elections office. So for a week, none of us could register voters, just for a week. So anything that reduces that burden and that delay is helpful.
Okay, thank you, ma'am. Members, any questions? We appreciate you very much.
Thanks.
Appreciate how quick you were able to be. Yeah, thank you. The chair calls Christina Atkins. Ms. Atkins, you're here on behalf of the Texas Secretary of State's office, of course, and you're on the bill as a resource witness, is that correct?
Yes, sir.
Okay. Members, any questions of Ms. Atkins? Have you had a chance to review this? Do you
Yes, sir.
have any concerns as to the logistics in trying to accomplish this?
I think from our perspective, anytime we see anything talking about an application or form, we're typically going to prescribe a sample, even if it doesn't have to be prescribed by the Secretary of State's office. So we'll do a sample form and probably provide resources that the county could use to talk about the changes in the law, just to ensure consistency.
Okay, yeah, because that was my question under B2 there about the, on any changes. I mean, y'all would maybe try and put together some type of a summary.
Yes, sir.
Put out. Okay.
Yes, sir. I mean, we do that anyway for all election-related laws, and I imagine that this would be, we would draw from that to provide some language that counties can use for consistency purposes.
Okay. Thank you. Members, any questions? Thank you. Ed Johnson.
It's okay, if you'd like to not testify, you can do so. You're in there twice now, so that's okay.
Let's see, we have you registered.
To testify and to not, so we'll delete one of them.
We have you registered to testify and to not testify, but we're going to delete the one that says to testify. Is that okay, Mr. Johnson? Okay. And we still have you as against the bill, is that right? That's right. Okay, all right. Thank you very much. Is there anyone else who wishes to testify on, for, or against House Bill 2351?
Yes, sir.
Yes, ma'am. What's your name?
Registered as Cynthia Van Manen. I just didn't sign up because I didn't know
All right, hold on just one second, okay? Thank you. Do we have her?
Yes, sir.
Okay, the chair calls Cynthia Van Manen. Would you state your name for the record?
Yes, sir. My name is Cynthia Van Manen.
Here on behalf of the Travis County Democratic Party and yourself, is that correct?
That's correct, sir.
And are you for the bill?
I am, sir.
Go ahead.
Thank you. And I'll keep this super short. I just wanted to recognize that the VDRs that we know in Travis County and the VDRs like the witnesses who have testified today who are VDRs in several counties are some of the most dedicated folks that I've ever met. And they don't do this because they have, affiliations with one party or another, though they may vote one way or another. They do this because they genuinely believe that people should be able to, they want to help people register to vote, but they also want to do that in a way that is lawful and compliant with all election laws and all the training that they receive. With this bill in particular, I think it provides some excellent guidance for counties and county elections offices to be able to, voter registrars to be able to expand the access available in these VDR training programs. And I also wanted to just mention that we are talking about renewals, so it's not, the first time of any training that someone would be able to do that through a process where they sign this affidavit. We are talking about people who have been through a training before, and certainly things change, especially in Texas election law from, year to year and every 2 years to every 2 years. But the Travis County Democratic Party has full faith in all of the VDRs that we've met, that they would be able to fulfill any sorry, if I had realized I was going to testify today, I would have written something. It would have been a lot more eloquent than I am right now. But so I thank you for your time. Just wanted to say that we're very much for the bill. I think it's a great bill, and I think it will help out VDRs as well. And we want to thank them for the service that they provide.
All right. So. Thank you so much for your time. Members, any questions of this witness? Thank you.
Thank you, sir.
Anyone else who wishes to testify on, for, or against House Bill 2351? If not, the chair recognizes Representative Vo to close on House Bill 2351.
Thank you, Mr. Chairman, members. Again, House Bill 2351 will make it easier for the VDRs to continue the service in the following electoral cycle without the current burdensome of free certification training. And with that, I close.
Thank you, sir. Members, any questions? No. Thank you so much. If there's no objection, House Bill 2351 will be left pending. I hear none, so House Bill 2351 is left pending. Chair lays out House Bill 380 and recognizes the esteemed Vice Chair Busey to explain the bill.
Thank you, Mr. Chairman and members, for allowing me the privilege to lay out House Bill 380. House Bill 380 would require the creation of 2 databases on the Secretary of State's website used for posting comprehensive elections information. The first database would build on what the Secretary of State already posts online for candidates and office holders at the federal, state, and county level each election cycle. We want to expand this requirement to include elections at the local level for city council, mayor, and school board. So those 3 additions. This database would include the name, office title, including any district, place, or position, and a notation that the person is an incumbent, whether the office is elected at large or by district, the dates for the preceding and upcoming elections to that office, a public mailing address, a public telephone number if available, and a public email address if available. The second database would aggregate election notices for all elections at the state, county, and local level, the county with whom a declaration of candidacy is filed, a state or county chair of a political party, or the presiding officer of a political party's convention shall provide information about a candidate or office holder of the Secretary of State. A political subdivision shall provide information about a candidate or office holder to the county in which the political subdivision is located, and the county shall forward that information to the Secretary of State. Last session, this proposal passed unanimously out of a committee, and it was separately added on the floor as an amendment of Committee Sub Senate Bill 7. We've continued to work on it over the interim, and I hope for your favorable consideration. Really, this is about transparency, so voters out there can figure out when elections are and who's running. Thank you, and I'll be happy to answer any questions.
Thanks, sir. Members, any questions?
I'd love to request. Yes, sorry.
Was there a fiscal note on it the last time? Have I got that right?
I think there will be a small one around maintenance.
Okay.
Putting stuff on the database online.
Okay. Oh, I'm sorry, last session, though, was there a...
I think there was, yes. I'd have to go back and pull the data to be sure, and I'd be happy to get that for you, but I believe there was.
Thank you. Members, any questions? All right, thank you so much.
Thank you, Mr. Chairman.
The chair calls Alan Vera. Mr. Vera, you are here on behalf of Harris County Republican Party Ballot Security Committee, is that correct?
That's correct.
And you're neutral on the bill, is that right?
That's correct.
Go ahead.
We have no problem with the goals of the bill for transparency and a centralized collection of this information. Looking, though, carefully at the new requirements for what the county party has to do, we don't have the staff to do this. In January of an even-numbered year, when the primary is gearing up, we get extra funds from the Secretary of State, and we do have extra staff for the primaries. But in odd-numbered years, we ain't got the bodies to put this kind of information out there in a county of our size. For example, the language in Section 141.032H requires every county political party to upload data for every precinct and every precinct chair, candidate, et cetera. We have 1,151 precincts in Harris County, and we probably have one person on staff who has to handle all of that. Again, we're not saying this is not worthwhile, but we'd have a hard time complying with the bill's requirements without some additional resources. The bill's language includes no penalties for missing items in the new information required, for missing deadlines, for missing an upload altogether. That's going to force, at the party level, at the county party level, is going to force some serious prioritization decisions by the county chair to decide which obligation to meet first and which one to be late on. The accuracy of the final data, we probably need to take a look at how to ensure that. Today in Texas, after every election, the voter rosters at the county level of the 15 largest counties don't match the voter rosters that are sent to the Secretary of State. There's discrepancies. How do we make sure that this doesn't happen in this new database? Without incremental primary staff funding from the SOS, without maybe an extension of the January reporting requirements in odd-numbered years, the county parties will struggle to comply with the requirements of the bill. Thanks for the time.
The chair calls Chris Davis. Mr. Davis, I think we've got you registered twice, once as against and once as on.
That's correct, sir. Earlier in the meeting, Mr. Chairman, TAEA switched their stance from against to on.
To on.
Yes, sir.
Okay, so you are Chris Davis, is that correct?
Yes, sir.
You're here on behalf of the Texas Association of Election Administrators?
Yes, sir. That's correct.
You are on the bill.
We are on the bill. Yes, sir.
Hold on just one second. Let me make sure we get that right.
Thank you. I hoped I registered as such on that correction, Mr. Chairman.
Yes, sir, now we're showing one registration.
We're showing one registration with you as on the bill.
On behalf of Texas Association of Election Administrators on the bill.
Yeah, so we have you as Chris Davis on behalf of Texas Association of Election Administrators on the bill. Is that correct?
Yes, sir.
Go ahead.
Thank you, Mr. Chairman. We recognize the value in establishing a clearinghouse for candidates and candidate listings on a statewide level. Clearly, not all city, school district, municipal utility district websites are created alike in terms of transparency and providing that information. This bill places that burden of aggregating that information on county election officers. And one of the issues is with counties and county election officers is they don't necessarily conduct all the elections in that county of cities, school districts, and MUD. Some counties have hundreds of political subdivisions, many of which aren't being contracted with that county elections office. So trying to herd those cats could be a challenge in the fluidity of candidate information. Being able to convey that, both aggregate it, make sure that it's current, and convey that to the Secretary of State's website. An older version of this bill in the last session placed the burden of reporting on political subdivisions. The actual filing authorities that candidates file with, those entities have the actual forms and all of that required information covered in this bill. And that older version cut out that middleman. And our concern is things that could be lost in translation. Candidate information that can often change, conveyed to the county, and then we have to convey that to the Secretary of State. But with those comments, I don't have anything else to say, and I'm happy to answer any questions.
Okay. Members, any questions? Thank you, Mr. Davis.
Thank you, Mr. Chairman.
Dr. Susana Carranza. Dr. Carranza, you're here on behalf of yourself and for the bill, is that correct?
Yes, that's correct.
Go ahead.
All right, so I fully support this bill. As a VDR, as a voter, as a person that helps inform others to find out what's on their ballot, I can tell you with certainty, it's a nightmare. You don't know where to look for information. If you think you go to the state level, you find something. You go to the county level, you find something. There is no centralized place. So having a database with everything in one place is a lifesaver for anybody. It's hard enough to know election dates in Texas. Good luck finding into your specific precinct and stuff, what you vote on. I sympathize that, who has the responsibility to send the information. It's, to me, organizations have to figure out who has the responsibility, but I think the priority is for the voter that stuff should be in one place and one place only, and it should be easy to access, because how can we be informed voters if it takes, a PhD in chemical engineering to find what's on your ballot? Thank you, Representative Busey, for this bill.
Thank you, ma'am. Members, any questions? Okay, thank you so much, Doctor. Appreciate it. The chair calls Ed Johnson. Mr. Johnson, you're testifying on behalf of yourself and you're against the bill, is that correct?
That is correct.
Go ahead.
Yes. So as you heard from Chris Davis, several hundred in the county-wide area entities. Well, take Harris County, for example. There are over 500 mud water districts in Harris County. There are over 30 ESD districts. There are no telling how many, utility districts there are. There are, I want to say, 27 different school districts, 27 different cities. Not herding cats. It's impossible to come up with this information. And the problem with this bill is there's nothing to enforce it. There's nothing in there that's going to require any of those thousands of entities I just mentioned just in Harris County to provide this information. So all you're going to end up with is a list of statewide elected officials that the Secretary of State puts together. That'll be it. It'll be the incumbency, where's my information? And that's the other one about this bill is asking for more information to be put online than what is required to file for office. So in many instances. So, you're asking for actually some of these people to put more of their personal information out online, these elected officials, which not necessarily I don't think is good sometimes with that. But it would be an impossibility to come up with this information unless there's some kind of enforcement tool. If you really want to enforce it, go to the tax office. Every one of these entities I just talked about gets their money from the tax office. They're all getting property tax. And if you put some strings on the property tax money, you would get the information.
All right, thank you, Mr. Johnson. Members, any questions? All right, thank you so much for your time today. Thank you. The chair calls Christina Atkins. Ms. Atkins, you're again here on behalf of the Texas Secretary of State's office as a resource witness, and you're on the bill, is that correct?
Yes, sir.
Okay. Members, anyone have any questions? Do you, Vice Chair? Go ahead, Vice Chair Busey.
Thank you, Mr. Chairman. We've been working with your office to get to the point, and just if you would speak to kind of the security reasons about why y'all had hoped and why we made the decision to have the counties report as opposed to each entity reporting to the Secretary of State.
Yes, sir. So with respect to the way this system would be developed, we have to leverage some of the existing resources that we have. We have our statewide voter registration and election administration database that exists now. What we would essentially be doing is expanding this to include information related to local elections, the date, time, location, those components, and then the candidate information. Those are basically the two broad categories. In order to do that, that would mean that we would have to bring more data into this system. We have some security concerns about bringing too many new users into the system because this is the database that does contain our voter registration information. It would be linked to that. And so we try to keep the number of users to that system limited just for data integrity to protect the overall system. In addition to that, there's actually provisions in the election code that limit who can access TEAM, and it does not, right now the law does not provide access to other local officials, local election officials. It is restricted to our county election officials.
Okay, so you've heard some of the, just to kind of sum this up a little bit, you've heard some of the concerns from like Mr. Johnson about, the amount of information that would have to be gathered. Do you share those concerns? Do you share concerns that we're going to be able to fully implement?
I do understand the concerns that Mr. Johnson had, and I will say I do understand and agree with some of those concerns to a certain extent. This is a large undertaking. It is. I mean, it's a transformative thing that we would be creating because it's aggregating so much data that's out there. I think I have kind of 2 points that I'd want to bring up with that. First, with respect to the data being online, there are provisions in the government code and tax code that require all of this information be posted on local entities' websites. So it is currently posted on local websites. It's just not aggregated anywhere. So, there are things that you can get through searching the web. It's just hard to know everything and have it all in one spot. So I think Mr. Johnson had articulated concerns that this is asking for more than what they're required to provide for running for office. And when I look at the list, it looks to me like it's consistent with what those postings already require as far as the content. The second component is this is a lot of information. No question. We're talking about, instead of 254 counties, we're talking about 1,200 cities, 1,200 school districts. I mean, it's a lot more information. And unfortunately, Vice Chair Busey, I'm sorry, that's why there's a fiscal note on the bill. There was a fiscal note last session as well, just to make sure everyone's clear on that. It did move forward even with the fiscal note. And just if I might explain that fiscal note does two components, or has two components to it. One, there's a technology cost associated with making these changes in the database. And then in addition to that, there's the necessity for us to hire additional personnel, which I think is kind of consistent with what you're hearing from some of the other testimony, is that it is a lot more information. It's going to be chasing that data. We want to make sure it's as accurate as possible. And so in order to maintain it and keep it accurate, we would need some additional staff to help with that, because it is a lot more that we're bringing into this system. And then, if I may, sir, there's one other thing that I had discussed with Vice Chair Busey's office. There is only really one component to this. I mean, even though it's a big undertaking, I think it is something that we put a lot of thought and consideration to, and I appreciate that the Vice Chair has taken some efforts to make this a little bit more manageable. But the one concern I do have is the effective date of the bill. Right now it has a September 1 effective date, and timing-wise that would be very difficult for us to do. So a little bit more time on that would give us the ability to implement it more successfully.
Do you have an idea as to how much more time?
So the date that I like is January 1, 2025, and the reason why, and you all laugh, but I have logic for this. The reason why is related to other procurement issues. Things that we're kind of at that time where we're close to contract expirations on our current system, and so very, very soon we will be pursuing the process to procure and update and upgrade our current system. And so tying these changes, because this is a pretty big structural change, into whatever future iterations of our statewide voter registration and election management system may be, I think could be more cost effective, and it makes sense to do it all at the same time. We don't want to spend a lot of money on a system that we may or may not have, depending on what happens with the next procurement.
All right. Yes, Representative Manuel.
I'm not going to say I have a quick question. I have a question right now. How often is the state updating its technology portion of what we're keeping safe for the voters' information?
Sure. So with respect to the bones of the system itself, we have state procurement laws that we have to follow, and so there's contract timeframes, sometimes the ability to extend contracts, and so it was about 10 years ago that we took on the current system that we have, that we moved over to this system, and then there have been some contract extensions for timing purposes. So I think before that, it was about 10 years before that as well. So that's kind of what we're looking at. So we're about to begin, we're around that time where it's time to look at what comes next and do some long-term planning.
So, again, wow, that was loud. Going back to kind of what you were saying before, if this was to be implemented, it would be better if we were moving this forward when we're updating the system, which we should. Well, maybe I shouldn't ask it this way. Do you think that we need to keep the system updated more? I'm kind of one of those, I guess, in that younger age of where I'm realizing how important technology is to the security of every single thing that we do, from the cars we drive to the phones that we talk and text on. And I'm wondering if that's something that should be updated more, because I'm kind of trying to get to where the vice chair's bill is and understanding, do we wait every 10 years knowing that there are always threats and information that we need is constantly reoccurring, or do we
That's a great question.
wait?
No, I'm glad you asked that because it gives me the ability to put a little more context. While we may be looking at, from a contract perspective, updating the technology and moving kind of to the next phase, please understand that we make updates to our system regularly with respect to security and efficiency. And so that is a constant process. In fact, particularly on the security side, we are constantly working with our vendor to make sure that our system is as secure as it possibly can be. And, not just looking at securing the system itself, but we also have a lot of measures in place to protect the data within that system, such as limiting our users to the system, requiring security training. But as far as modifying the system, we are constantly updating and enhancing. We're not just talking about a product that was purchased 10 years ago and then just sits there. Every legislative session we have changes we have to make and implement, and we're just very, very aware of the importance of making sure that this is as secure as it can possibly be because it's protecting very valuable data.
So it's refreshed, and of course, I'm not asking the time frame. I wouldn't want to put that, but it is something that is consistently refreshed.
Absolutely.
We're not dealing with, it may be Windows 95, but it's still up to current date.
It's definitely not Windows 95.
Right, I'm using it as an example.
Yes.
Thank God it's not Windows 95.
Yes,
Windows 98, sorry. No. But it is something that we're constantly making sure
Absolutely.
that we are up to currently what is today to
Yes,
keep
sir.
the integrity of our voter system and voting information.
Absolutely. Yes, sir. Top priority in our office is election security.
Appreciate that. Thank you so much.
Do you have anything else you want to share about this? Because a moment ago, he prompted you, like you had something you wanted to talk about.
No, sir. I think that the questions that you've asked have given me the opportunity to put some more information out there that I hope you consider.
Okay. All right. Well, thank you. Members, any questions? Any more questions? We really appreciate your time.
Anytime. Thank you.
Oh, is it your birthday?
It is not my birthday today.
You let us know when it is, all right?
Sure.
Thank you. Is there anyone else who wishes to testify on, for, or against House Bill 380? If not, the chair recognizes, wait, I'm so sorry.
I promise not to make it a habit, sir.
Hey, you keeping us on our toes today. I appreciate it. Yes, ma'am.
I'm Cynthia Van Manen. I'm registered for the bill. I'd like to testify.
Yes, ma'am. Give us 1 second.
Just 1 second. Got it? Okay, Chair calls Cynthia Van Manen. Ms. Van Manen, you're here on behalf of the Travis County Democratic Party and yourself, is that correct?
That's correct, sir.
And you're for the bill?
I am, and the party is as well, sir.
Okay, go right ahead.
Thank you. I just wanted to preface this with, I'm the executive director of the Travis County Democratic Party, and we're responsible, of course, as you know, for administering primary elections in Travis County. I am sympathetic to some arguments that some county parties don't have the staff to be able to maintain these records and update these records. From my read of the bill, this is for the offices, the candidates for the particular offices that file with county parties. This is already what we're required to keep and to upload to the Secretary of State's system, to team, as the representative mentioned. And we are a staff, right now we have 2 FTEs, 2 full-time equivalent employees, and we might have up to 6 or 7 during an election season, but it's not been a challenge for us to do that so far. So for us, that's not a concern. Certainly, we can't speak for every county party. Most county parties in the state don't have staff, frankly. And of course, being a county chair is a volunteer position. But we think that this is a great bill, and for many reasons, and you've heard some of them today, one of which I will add to, is that I think that it will help people learn a little bit more about who their local representatives are. If they can go to the Secretary of State's site and see one definitive source of who their city council member is. In Travis County, obviously most of that county is Austin, but we do have several smaller municipalities and several elections. We've got elections coming up in May in a few of the smaller municipalities, and I think that this would be beneficial for the people of Texas for that reason. So, thank you, sir.
Thank you, ma'am. Members, any questions? Thank you so much for your time.
Thank you.
Is there anyone else who wishes to testify on, for, or against House Bill 380? If not, the chair recognizes Vice Chair Busey to close on the bill.
Thank you, Mr. Chairman. Just to address some of the issues, we did pull the fiscal note. Last time it was 1.1 million. This time it's 1.3, maybe inflation. Mr. Vera's point about odd years, I want to make sure we get together, so our team get with you to address that. I think what we're dealing with here is just about like what elections have happened and are coming up, but let's make sure we're on the same page, so I'd like to work with you on that and continue to work with the committee. We addressed why is it the county sending all this info? It's because who has access to teams and security as opposed to every group doing it. But I'll just close with this. I think the question here is who is on our ballot and when are the elections? I think that's a small price to pay to make sure everybody can know that kind of information. It was said it's impossible. That's not a Texas spirit that I know any of us to believe in. We can get this done. For $1 million, we can know where our elections are going to take place, who represents us, and who wants to represent us. I think it's a small price to pay, and I close. Thank you.
Members, any questions? Thank you, Vice Chair. If there is no objection, House Bill 380 will be left pending. The chair hears none. House Bill 380 is left pending. The chair lays out House Bill 1848 and recognizes Representative De Ayala to explain the bill. My understanding is this may be your first bill layout. Is that right?
It may be.
All right.
It may be, which is why I was thinking to myself how intelligent and probably the most handsome person on this committee, Vice Chairman Busey, might have been. In all seriousness, House Bill 1848, this relates to a study request by the Secretary of State on the feasibility of central accounting stations complying with certain facility standards known as SCIF, Sensitive Compartment Information Facility. It's pronounced SCIF. This term originates from the Department of Defense, but it's used outside of that context, and it can be used for a secure room. It can be a data center or a secure room that guards against electronic surveillance and suppresses data leakage of sensitive information. SCIFs are used to deny unauthorized personnel the opportunity for undetected entry into facilities for the exploitation or improper use of sensitive activities or data. SCIF is a set of standards that exist currently, again, like I said, originating in the military, but outside of the military as well. We have several examples to study in real life and to see if those standards could effectively be incorporated to central count. Currently, central count voting areas are not SCIF compliant, and there has been no study of whether or not this would be beneficial or cost effective to central county voting stations. This bill is simply requesting the Secretary of State's office to run a study of the cost and feasibility of making central counting stations SCIF compliant and whether or not it would be beneficial in the process of further securing our elections and helping restore voter confidence in the election process. The whole purpose of requesting this study is to potentially further reassure voters that protocols and standards are in place, that no vote counting equipment in Texas can be manipulated or otherwise accessed by unauthorized personnel, or that the current standards or protocols are sufficient. It's basically just a study to see if it's feasible and cost effective, if it's the right thing to do or if it's not. With that, I'm happy to take any questions.
Members, any questions? Representative Swanson.
Yes. Now, do we get to haze him since he's a freshman and from my county?
That's all on you. Well,
please.
Maybe not.
Bring it on.
Certainly later we will.
Okay. No, actually, this sounds like an excellent bill, and I think in this day and age, it's time. It's necessary, and it would not only solve the problem of the very possibility of election fraud, but it also would help calm the voters' concerns about whether it's going on. So I compliment you on this bill, and I'm really not going to haze you.
This time. Thank you, Representative Hodgson.
Thank you very much. Members, any other questions? All right, let's go for it. Bill, we'll get you registered right here.
With that, I reserve the right to close.
Yes, sir. Thank you very much for your presentation. The chair calls Alan Vera. Mr. Vera, you are here on behalf of the Harris County Republican Party Ballot Security Committee, is that correct?
That's correct.
And you're for the bill?
That's correct.
Go ahead.
Thank you. This bill simply calls for a study by the SOS of the cost and feasibility of making central counting stations in Texas SCIF compliant. SCIF stands for Sensitive Compartmentalized Information Facility. It's covered under the Intelligence Community Standard 70502, which I'm holding up right now. If you'd like to read it while you're trying to go to sleep, feel free to borrow it. A year ago, most citizens had never heard the term SCIF. But after classified documents were discovered in the homes or offices of former presidents, former vice presidents, and current presidents, the phrase SCIF was exposed in the media. Many of you have already heard that when members of Congress are allowed to review classified documents, they have to do so in one of the congressional SCIF rooms. Essentially, a SCIF-compliant room is a Faraday cage. It's a sealed, secure facility where no signals of any type can enter or leave. Why should Texas do a study of the cost and feasibility of making Texas Central County Stations SCIF compliance? Quite simply, it's to see if we can afford or can implement one solution to help restore some lost voter confidence. Across the state, there's a growing concern, valid or not, that our election counting computers in central county stations are vulnerable to hacking or other outside meddling. You can hear that expressed every day. In this very building, in January of this year, there was a fairly large conference on this topic sponsored by a grassroots group called Texas First. Many speakers at the conference presented, quote, evidence, air quotes, of election tally computer hacking and called for an end to the use of computerized vote counting in Texas. There are bills in the Texas Senate today supporting this concern. Now, we may not be able or even willing to address every single concern being raised about voting systems in Texas. There are a lot. But the issue of hacking or otherwise accessing our county's vote tabulating systems in central count may have a solution. We just don't know today whether we can pull it off or whether we can afford it. The study proposed by this bill will answer those important questions. Pretty simple, I think. We ask the committee to give House Bill 1848 favorable consideration.
Thank you, Mr. Vera. Members, any questions? Okay, thank you so much.
Thank you.
The chair calls Susana Carranza. Ms. Carranza, you're here on behalf of yourself and you're against the bill, is that correct?
Yes, that's correct.
Go ahead.
Well, since this is a study bill, some might say there is really no harm in pursuing. In my view, there's a lot of harm in pursuing something that it's pretty obviously unfeasible. As an engineer, I worked for over 20 years for a small company doing research for government agencies such as NASA, the DOE, and the DOD. As you might expect, these agencies have facilities with different levels of access, not all SCIF. For SCIF, it's really the highest level of security, stuff that you wait for, like cabinet level. But in general, secure data centers at different levels, like you can't get in, you cannot have, like you have to have security level clearance to be a SCIF. Like if every employee, imagine every person that works at a facility has to have security level clearance. Every person that it would go into the facility that doesn't work there, doesn't have security clearance, either has to have security clearance or has to be escorted to the bathroom every time. I mean, just think about the procedures that happen during counting. And you're going to get county officials to have security level clearance to be qualified as SCIF. Like if you're going to call a standard, have the DOD being consulted, because I would think it would be a waste of tax dollar money to do a study with something that if you pretty much just ask any resource witness from the DOD, it would be incompatible, especially because the bill mentions if this is compatible with poll watchers and citizens watching. It's like, how do you reconcile having a secure facility with really limited access and then also get outsiders? You actually cannot get information outside. It's for your eyes only type of information. It's all contradictory with, having secure, but having poll watchers, or having even any citizen that's not even training a poll watcher. And even things like, if you need any sort of service, your IT team has to be 100% part of the system. Your IT has to have security clearance. I can tell you, even if it was possible, if somebody decided this was a good idea, it would be absolutely insane cost to have full-time personnel that all with security clearance. I'm absolutely opposed to this bill. It's just because it's a study, it doesn't make it like, oh, let's just do it and find out. It would be a waste of tax dollars. Thank you.
Okay, thank you, ma'am. Members, any questions? All right, thank you so much.
All right, thank you.
The chair calls Ed Johnson. Mr. Johnson, you're here again on behalf of yourself, and you're for the bill, is that correct?
That is correct.
Go ahead.
Thank you, committee, chairman. Everything that you just heard from the last testimony on, things that people would need to do needs to happen in central count on election night. Because, and let's not say election night, let's go with, they actually start tabulating votes at noon on election day. Remember, the early vote machines are already in, and they can start at noon to tabulate them. And I went in Harris County, we actually had a sealed off room. Everybody that came down the hall had to have a special pass. You weren't allowed to take your cell phones into the room. And once you went into the room, you weren't allowed to come back out. There was a restroom attached to the room, so you could use the facilities if you needed to. But once you start counting the vote, those people cannot be allowed to have access to the public to reveal how the vote is going. The election code says that you cannot reveal the vote until 7 o'clock that night when the polls close. So, yes, you need a SCIF room. You need to have that security, because whoever starts this process of counting the votes should not be able to connect with the outside world to tell them how the vote's going. You don't want them to be able to manipulate a race that's real close by saying, oh, you're ahead or you're behind, when they start counting early votes there on election night. So, yes, a SCIF room is needed to ensure that the information in that central count room, the central count is where the votes are counted on election night or election day, it needs to be very secure. And it's not rocket science on the technology here. I was baffled back in 2018. We made an iPad system in Harris County. We developed our own for poll book systems, and we wanted to make sure that we could communicate with this iPad no matter what. So we were communicating it with Bluetooth and Wi-Fi and cell signal. And some of the newer schools we would go into, we'd go inside the classroom where they have us to the polling location, and the thing would stop working. We couldn't talk to the iPad at all. And I'd walk in the room and it'd just go dead. And I'd walk out of the room and it would work. I walk back in the room and it would go dead. And, I finally called the IT guy and said, what the heck's going wrong with your school? It's really weird. And he goes, oh, I thought you were supposed to be in this classroom. And then when he turned off all the security measures that were in that school, all of a sudden the iPad started working. So, school districts are using, you got every kid in the school's got a cell phone. How do you keep them off of, getting to the outside world on their cell phone when they're in class? School districts have already figured this out. It's not rocket science. I mean, it's being done all over. So it would be an easy thing to implement, to do. So I think it's definitely worth the study.
All right, thank you, Mr. Johnson. Members, any questions?
Mr. Chairman?
Yes, Chairman, before you go ahead.
All right, thank you. Hey, and I don't know much about how central counting works, but when does that process start when they do that? In other words, how long would this room or this area have to be in place for?
it starts on election day at noon, and it continues until you get the vote counted. So hopefully, by midnight or sometime early in the morning on larger counties, you would be through with the process. And
so in this room, in terms of what the previous witness has said about, you're going to have to get all this stuff and do all this stuff, it's really for a limited amount of time, mostly.
Yes, a very, very limited amount of time, probably 12 hours max.
Right. So you don't necessarily have to worry about making sure there's all these people that go in and out. I mean, I'm not trying to work on the study already, but it sounds like it would be a limited amount of time.
Very limited amount of time. You start at noon usually, and you start with testing the election equipment. They call it a logic and accuracy test, where you test to make sure the equipment is working correctly.
Yeah.
Both parties are there. And then from that, you start proceeding into tabulating the early vote. You're reading the early vote memory cards. And when we were running it in Harris County, when you went into that room, i.e. you had to be on the list, you had to come and get your badge, and you went into the room, and once you went in, you couldn't come back out until 7 o'clock.
Can I ask you, I think you had mentioned a portion of the code that says you can't, because this is the part I'm most interested in, you can't communicate the current vote counts. Because you're right. I mean, if you're counting, let's say, the early vote count, you may already know who won the race or if it's close or not. So how do you, other than the law, how are people prevented from sharing that information? Are they allowed to come in with their cell phones right now?
Well, it's not in the law that you can't. Now, in Harris County, we took it when another regime was running the county, we took it very seriously, and we would limit anybody going into that room from being able to communicate to the outside world. You had to...
But there's no law that says...
There's no law that says you can't, but, it was our county policy that you didn't take your cell phone into the central count room because, you can't be communicating or texting or talking to anybody.
So there are folks that at 1 o'clock or 2 p.m. or 3 p.m., as early voting precinct information comes in, a lot of it electronic, so rather quickly, on election day, well before the election results are posted, that know what the results may be, and can share it with other people.
Yeah, so after 7 o'clock in the polling locations on the electronic machines, you get a count, the election judges count of who voted in that poll, and they have those results with them. But they don't run that until after 7 when the polls are closed. After the polls are closed, then yes, you can communicate with the outside world. But until then, when you start at noon, and from noon until 7, that central count room should be on lockdown, and no one should be coming or going.
All right. Okay, thank you.
Yes, sir. Representative Manuel.
Hello.
Yes.
Quick couple of questions. What would be the qualifications for the person to be able to be within that room? Because I have a sister, she has been working with classified documents for over 15 years. So I understand there are classes you have to take, credit report, things of that sort. What kind of qualifications would be the qualifications for a person to be able to have access to this SCIF room to work through the elections, in your opinion?
Okay, so, it's in the election code who's allowed in the room.
No, I just wanted to make sure there weren't any changes, because I'm looking at this from both ends. And so I do understand the point of, yes, there are election laws now, but if you're asking for a classified, are you wanting to update that to add more precautions into it, or are we just sticking?
I think what's in the code currently is sufficient.
Okay.
You have a central count judge and alternate judge. Mm-hmm. So the gubernatorial candidate that won the county's parties picks the judge, and the other parties the alternate judge. Then you could have a poll watcher,
right,
that could go in there, and then you have the election administrator. And
so you're finding not changing it,
and then
updating it to anything else.
Then members of their IT staff that need to operate the equipment.
Okay, and so that was my second part. I'm getting to that, because that's what I kind of want to make sure is what the intent of where we're going with this. Because I get what you're saying. I don't think we do not need to have secure elections or have people have faith in them, but I think we need to also be sure of what we're asking, because we know a lot of these people are volunteer. We don't have elections every week, thank God. But when it would come to the IT person or persons, since we're looking at a skiff room, since these people don't have access to the outside world, would the IT people also be in that skiff room, or would they be? So they would have to relocate from wherever they are on a normal basis to be in
Harris County. We had 3 guys, for Harris County, which is the 27th largest state. So it's 3 guys ran the central count, and the skiff room.
No.
Because the central count,
they're going to be.
Yeah, the central count. That's part of the skiff philosophy and current election code. That central count computer and equipment cannot be connected to a network.
I'm wanting to see where you want it to be. That's my question.
I want it to be there. I don't think
the idea, right? I know that part of it, but I'm asking. So you would like both people, the workers, the judges, and all IT personnel to be in that skiff room with their cell phones, having an adjacent restroom, locker, whatever it is, to where they don't have access to the outside world. Making sure that I'm assuming that all IT people's computers are locked to make sure that they're also not being able to use county computers to work from that. Okay.
So there's one person that's in that central count room that should be allowed to leave. Okay. And that's going to be whoever's going to post the votes on the internet or wherever your votes are posted on the Secretary of State's website. So that person has to leave the room with a memory drive with the results on it and go to a computer outside the skiff room to upload it to the Secretary of State's office.
Okay, and so the other thing is, who would be securing to make sure that people are not leaving, in your opinion?
I'll tell you what.
The EA would.
I appreciate the questions. Okay. And I know we have a resource witness who also is going to be able to give us some.
Probably a lot more knowledgeable than I am.
But the other thing is, we want to confine our questions to the bill, which is about a study for what it's going to take to set up.
Well, I was trying to get to where his questions, his answers of how he wanted it to be run, because I know that we all have, not going towards the author's intent, but I know sometimes we have different understandings of how we want things to be implemented, and I'm just trying to get it from, but I completely understand where Mario's intent for everything is going, but I'm also trying to get understandings from both points of view. That was it.
I understand. And
thank you so much.
Yeah, thank you. Thank you, Representative Emanuel. Great question.
Can I have one quick closing? I really think that this technology or study, if it's implemented, would really knock down a lot of the doubt that are in voters' minds on if their elections are true or not. It would be a great confidence builder.
I happen to agree. Thank you very much.
Thank you.
Mr. Johnson, thank you. We call Christina Atkins. You are Christina Atkins. You're here on behalf of the Texas Secretary of State's office. You're neutral on the bill, and you're here as a resource witness. Is that correct?
Yes, sir.
You heard some of the questions that Representative Emanuel was asking that I thought were quite good. And that kind of all dovetails into some thoughts that I had about really on this study. What is all required in being able to set this up? Do you have some information on that?
Sure, that's a great question. And if maybe I could just take a brief moment just to tell you the parameters of a central counting station as they exist now. Just to clarify, central counting stations for counties that are over 100,000 in population can begin as soon as early voting in person ends. So for our larger counties, it could be a multi-day event. I think with some of the way some of the voting systems have changed over the last few years, there's now more paper components to systems. And so maybe in the past when Mr. Johnson was working elections and they were using electronic voting system equipment, they may not have had a need to convene central count for so long. But I think a lot of our larger counties do now because processing paper ballots does take more time. In the processing of ballots at central count, you are counting ballots. There are state laws that prohibit you from releasing any results until 7 p.m. on Election Day. So it is a criminal act to do so, to address some of the questions that you had, sir. And then I would say on top of that, there are other provisions right now currently in law that say that if you are doing any kind of counting activities that may be authorized under the law for larger counties before Election Day. Right now, we have administrative rules that say that you can't print any reports to show results. So there are some protections built into that. One thing I do want to mention with respect to the feasibility study, specifically to what you're looking at, sir, is I think when we're talking about a SCIF, there's some very interesting points that were brought up about the security components to it and whether or not this is feasible to do with our current situation. You know, looking at some of the practical side of the central count process and thinking about poll watchers and this increased desire for transparency, that's where I think, you know, there's an interesting intersection there. What I don't know is how SCIF standards could impact that transparency notion and that desire for more information and more public information. I don't know where that intersection lies, which is maybe what I think your intention might be, sir, with the study. And so these are very good questions. I was taking notes in the event that this is something that my office is required to do.
So do you have, I mean, would you all try to do this in just one county, or would you pick multiple counties? Do you have any idea on how you would try and conduct the study?
That's a great question. I think that first and foremost, the way I look at this is we'd probably have to do some pretty substantial research on what the standards are for a SCIF. Just kind of my brief research that we did a little bit in preparation for this meeting made me realize I need to do a little bit more research beyond just some brief research, because it looks like there's different types of SCIFs and then different levels, and so I'm not sure what would be feasible in Texas, but those are things that we would have to look at, is what the SCIF standards are, what the different types are, and then how those relate to current Texas election law. Those are the things that we would evaluate.
Okay.
Mm-hmm.
And I see here in the bill that it provides that no later than September 1st, 2024. Does that sound like that's something that could be accomplished by then? Do you have an idea?
Sure. I mean, I think that, you know, if whatever charge is put on our office, we're going to do what we can to, you know, to meet the deadlines that the legislature requires. Absolutely.
I understand that.
This one doesn't give me anxiety like the database that we were talking about before.
Okay. All right. Good. Mm-hmm. Good. Because we had this discussion one time in connection with the OCA deal, and
yes, sir.
I understand.
Yes, sir.
They performed a miracle for us. And try not to have to make you perform any more miracles. But,
it's what we do well in elections. We're
outstanding. Members, do you have Representative Peniel? No, she answered your questions? Excellent. Okay. Excellent.
Actually, no, I do have one question.
Yes, sir.
I'm lying.
Thought you might.
I'm trying to be that freshman that learns. Under this, who would be in charge of security over all of this? I know that it's kind of theoretical, but from, I guess, your interpretation, who would be over security, making sure that IT personnel are following? And again, I know this is a study, but I'm going off of if the study happens and it shows that it's something that would be good,
sure.
Who would be over making sure that people are, you know, where they're supposed to be, all that kind of?
And I can answer that question for you. Under current law, I believe that would be the manager of the central counting station. And that's typically going to be your named county election official or somebody that works directly for them.
Perfect. Thank you so much.
Yes, sir.
Members, any other questions of our great resource witness? Thank you so much for your help today.
You're welcome. Thank you.
Appreciate it. Is there anyone else who wishes to testify on, for, or against House Bill 1848? Hearing none, I invite Representative De Ayala to close on his bill.
As I was sitting up there, I was thinking about Box 13 in the Duke of Duval County, and I was thinking of Florida and the Hanging Chad, and then I was thinking about the more recent elections locally, nationally, and all that stuff. And what comes to mind is this. The goal of this is to study and learn and see where we go from here, to get some standards and practice. The goal of this is to make sure that the voters of this state, and hopefully as leaders of this country, really respect better than we do today, that every vote counts, every vote matters, and our elections are the gold standard of the world, which is what we need to be. And I know that sounds a little bit ideological, but This is the kind of study that I think gets us into those steps to where now that we're in this electronic phase, this digital and internet and all this stuff that some people don't understand as well as others do, it's nice to have some standards that tells us, hey, we're doing it right. So with that said, I urge that the committee look favorably on this bill, and thank you for your time.
Thank you. Any questions of the representative? Thank you, sir. If there is no objection, House Bill 1848 will be left pending. I hear none. Therefore, House Bill 1848 is left pending. Members, that's going to conclude our agenda today. I will want to, unless anyone has any other comments, I just want to say a couple things. We are going to have a formal meeting either on Monday or Tuesday. We'll be advising you tomorrow of when that will be so we can vote out some bills. We did not do so today because we had one or two that we were working on some committee sub-language on. My understanding is we've got some of those bugs ironed out, and so we'll be notifying your offices about the formal meeting so we can get some bills voted out of here. I also just want to thank everybody, congratulate everybody on the way we're handling these hearings and the decorum we're maintaining, and I appreciate our audience for taking part in the process and all the witnesses today, and I just hope everybody has a great weekend. We will stand adjourned, subject to the call of the chair.